பேசுறேன் மேம். பாருங்க அதான் வாட்ஸ்அப் இப்போ வந்து யாரோ அங்க இதுலயா மும்பைல அனுப்பிச்சு தரேன்னு சொல்லி. யார்? மாதவன் சாஸ்திரி. மாதவன் சாஸ்திரி யாருன்னு தெரியல. அனுப்பிச்சு தரேன்னு சொல்லி. ಆಯ್ತು ಒಟ್ಟಿದ್ದಾರೆ.
The appellants have filed a memo for withdrawal with respect to 3 appeals also.
RFA now are not listed. Because of the notification.
They are seeking for the withdrawal of the appeal.
Even then. Difficult.
Please.
You filed the memo in the.
Memo is already filed in the year 2022.
If a decision is taken to take up the matters, then it will become.
Please, my lord, then
That's better. File it, whatever it's worth.
memo is already filed in the year 2022 itself. If the subsequent order comes, I'll move the memo.
Let it remain. Let's see in what manner the development takes.
Please, my lords, please, much obliged.
My lord, on submission. In RFA, my lord,
Same thing,
here,
same thing.
the suit for partition, though they are taken the license from the municipality and demolishing the property, my lord. Is very urgency, my lord. If they demolish the property, portion of the property is already been demolished, my lord. Hence, I request for an tomorrow itself, my lord, to hearing on IA.
It is not possible. Today, we don't have RFAs on our board. Getting the point, just
Wait up to 26th, it seems.
just wait.
My lord, even my matter pertains to an RFA, my lord. The thing is, my lord, for non-payment of court fee, it came to be
Whatever
dismissed.
may be the reason.
Please,
RFA means RFA.
please.
It's not going to the facts or the merits. Okay, RFA would be an issue. So better just wait.
Please.
We say nothing because surely RFAs are not listed. That's what we are saying. Okay?
Please, my lord.
Which are,
Admission preliminary.
Yes.
My lord, one matter just finally. The 2003.
What is the petition? Is it an appeal? What is it?
Classification.
Is it an RFA?
RFA.
Same thing, like him.
You file it in the counter. If we decide to take up, we will take up. Wait up to 26th.
Memo of posting should be filed in the counter.
You file it there. You file in the counter. They'll take a call on that ultimately.
Achha.
Yes.
Germans. Page number 8, serial number 20 and 21.
Lordships, in serial number 21, appear for the appellant. I seek for a short accommodation, Your Lordship, I'm led by a senior advocate. There's some inconvenience today.
Which number you said?
Serial number 21, Your Lordship.
21.
Hmm.
Who is seeking adjournment?
I'm for the appellant, Your Lordship.
You are seeking adjournment.
Yes, sir.
Have you informed the other side?
I have attempted to contact them, Your Lordship.
No attempt. Must inform.
Yes,
So that they should be in the knowledge.
yes, I will
Just
inform them.
them and mention it. Inform them and mention it.
Page number 9, 22 to 24. Page number 10, 25 to 27.
My lord, CR number 25, my lord. My lord, I am for appellant, my lord, praying for short accommodation. We have to,
Praying for?
short accommodation, my lord. We have to file a translated copy. 25.
State this. Have you informed the other side?
My lord, it's a government advocate.
You are here, no? Just say this, the learned counsel for the appellant seeks how much time?
2 weeks time.
2 weeks to comply with the office objections based on again 2 of 23. He also states that the English translation of Kannada documents shall be filed within the same time period. That's all?
Yes.
We notify after, give a date. Give a date. It's not in July, at least in August, give a date.
Fifth of August. Page number.
Submission. On submission, madam. Page number 1, list number 1.
Wait,
Wait.
we'll take up that.
Serial number
Office objection, it is listed.
7.
Please.
Adri,
List one, serial number 1, Shreyasri Bhatt.
Appellant in this matter. Pray for 2 weeks time to complaints.
14 office objections,
There is 14 of the objection, my lord.
each time is granted.
Please.
Huh? Saka,
2 weeks,
14 ಇದೆ, ಯಾವಾಗ ಮಾಡೋರು ನೀವು? 2ನೇ ಸಲ ಬರ್ತಾ ಇದೆ.
please. 2 weeks ಆದ್ಮೇಲೆ
Has it been dismissed earlier? Has it been dismissed?
no, my lord.
No, it has not been dismissed.
No.
So 2 weeks, you will clear all the objections.
Please,
Otherwise, we will say it's dismissed.
please.
2 weeks. When the counsel for the appellant seeks and is allowed 2 weeks to remove 14 office objections. This time, shall we say, no objections. We notify after 2 weeks. Give a date, give a date. Give a date.
Please.
Serial number 2, Shri Sundaresh.
Appear for appellant in this case.
For the respondent.
Madam, one office objection is a pray for weeks time.
What is the office objection?
So I have already completed the office objection. Again, madam, the registry has raised some objections, but I objection, but I don't know. Only one objection.
English translation.
A week's time is granted to the counsel for the appellant to file the English translation of all documents which are in Kannada. How much? 2 weeks?
For English translation, but I need at least 3 weeks, madam.
4 weeks?
Please.
26, 22, 7. Serial number 3,
Lords, appellant number 1, my lords, I filed wakalat for appellant number 1. The earlier the matter was dismissed for non-prosecution. I had filed an application for recall. My apologies, it is not accompanied with delay application. Lords may grant me 3 days or 4 days time, my lords. I will ensure, my lords, a week's time, my lords, I will file delay application.
So the counsel for the appellant states that an application seeking condonation of delay in filing the application for recall of order dated 1/10/2018 shall be filed within 1 week. So noting the said, stop noting the said submission, be notified.
Yes.
serial number 4,
What is the date now?
15,
15th? 15th of?
Lord, on 11/6, my lord, I filed amended the cast title. And also, my lord, amended the cast title in the court itself. My lord. Still member. As a service of EA on the other side is concerned, it was served, but signature was not taken. I will once again serve, my lord, take the signature and file a memo.
What do you want?
Lord, pray for 1 week time, so for a service of copy of IM, Lord. Amended cost rightly is concerned, Lord, I have done that.
Filed, ah?
Please, Lord.
You have filed?
Yes, Lord, on 11/6 I have filed.
Copy served, copy to be served on the other side. Translated copy kodಬೇಕು.
Well, I will serve
How much time you want?
one week, Lord.
Week to- 1 week to comply, 1 week to carry out the objections. Please clear the objections as notified by the registry. Just on
7. Serial number 5, Shri Fayasa. Serial number 5. Serial number 5.
When appear 1 week. To comply the office objections.
8th of July. 8th of July. Serial number 6, Shri G.S. Prasanna Kumar.
My lord, appearing for this appellant in this matter.
yes,
There is office object raised for respondents which has not been
the
complied with.
objections to the writ appeal. The objection.
Non-compliance of objection goes to application. Index sheet to be filed.
Objection.
Office objection may be overruled.
The office objection in respect of the index sheet by the counsel for the RS respondent number 1 is overruled. Establish the writ appeal for admission on. Give a sufficient.
My lord, I'm sorry, I could not hear the date,
16th of July.
July, madam.
Grateful, my lord.
Serial number 7. Shri
Pray
Govind
for
Raj
applying,
K.
Lord. I pray for 1 week time for filing synopsis.
For filing?
Synopsis.
Synopsis.
I appear for the fourth
Week time.
respondent.
Show me that form.
Sir, my accused means.
For the state,
I appear for the private respondent, respondent number 4, my lord.
for that bull was your,
They belong to
who
me.
made the complaint?
I made a complaint to the third respondent commissioner, and the petitioner is challenging that the third respondent has no authority to proceed with the matter. Only point is whether the commission is entitled or not. Short point is,
To give directions.
to give directions. Matter pertains to the year
Where
2000.
file your synopsis,
I have
argument.
I have not found.
Both of you file it. You have any judgment, just enclose it also.
Okay.
Counsel for the parties to file their written submissions, oblique synopsis. Along with the judgment they want to rely upon. Within how much time?
A week's time I will file. 1 week time I will file.
Say 2 weeks, list for hearing on, just give it in August. 15 July. Don't clog it. You should keep it. You said 15 July.
Serial number 8.
I appear for the petitioners.
I'm representing
Deputy
respondent,
Gowda.
but respond number 2 and 3 in the first matter.
You represent all the parties,
Please, my lords.
all of you.
Please,
Some of
my
them
lords.
are.
This.
We can hear this.
Any day,
Can
my
we
lord,
hear
may
it?
fix a
Lords,
day.
my difficulty is, my lords, the arguing council is coming from Delhi, my lords. If your lordships could have this matter on the 4th of July. It's ready for final hearing. In fact, it was heard by the honorable coordinate bench.
Was directed to file synopsis in the matter, my lord. My synopsis are ready. I'll file it during the course of the day, my lord.
Lordships may kindly take order dated 6/2/2024. It was heard in part, then due to change in roster, my lords, it was
Have you
released.
filed your synopsis?
I have completed
My
my
synopsis
pleadings.
is ready, my lord. During the
File
course
it
of the
then.
day, I'll file.
May I
So then
request for
the-
the 4th of July, please?
My lords, the fourth, we
The
have some difficulty.
Counsel for the party shall file their written submissions oblique synopsis along with the judgment they want to rely upon at least 1 week before the next date of it. List on.
My lords, the fourth, we have some difficulty, may I request?
Whichever date convenient, just
Lords,
discuss.
in the alternative, may I propose this, my lords? We will commence with our arguments. Let them, my lords, thereafter,
He'll be there, ma'am.
please,
This is the
he'll be,
difficulty. What is your convenient date?
My lords, any day the next week after fourth month.
Just give
ninth,
any
ninth.
date next week.
11th, please.
grateful.
Wait.
Next.
Serial number 9, Shri B. Vachan.
Lordships may kindly permit me to comply with the official objection so that my recall application may be considered, my lord. It's dismissed for default, my lord. If I may be permitted to comply with the office objections, so that my application can then be considered, my lords. The reason, my lords, is that, my lords, this is an old appeal that I had filed. I was unable to secure the papers in time, my lords. Now I have the papers.
You couldn't calculate the number of days delay?
Yes, my lord, I had calculated, I think my mistake, my lords.
When the matter was
I'll comply.
dismissed is there, how many delay is there?
I'll-
Is calculable. And
Although-
just mention it in your application, that is the rectification.
I'm
which-
sorry, my lords. There would have been 2 more days because we have to send the papers for the signature of the officer concerned, then get it back. So when we send it, we don't write it, so we write the correct number of days. I must have missed it writing it, my lord. I am very sorry, my lords. It's only that I didn't want to write it incorrectly. At the time, on the day of filing, we write it, my lords. On the day of filing, we write it because when we draft it, we don't write it so that the days are not incorrect. We send it to the officer concerned. Sometimes they're not available for a day or 2 for signatures.
That's very important, the number of.
I
days.
understand, my lords.
That's shows in the sense that in what manner the application need to be dealt with.
It is just that, my lord, we want to write it correctly because we don't write it, mention it at time.
Calculate it.
I'll-
Calculate it and
I'll write it, my lords. I'll write it. I'll complete when I'm complying with the office objections, my lord. If your lordships permit me, I'll comply with the objection on this application. Also write the number of days.
Matters with that list.
how much time you want?
My request 2 weeks, my lord.
We will give you 3 weeks.
Please, my lords, highly obliged. I'm very sorry, my lords. I have not written the number of days.
Do it positively.
Please, we'll do it, my lords.
The counsel for the appellant seeks and is allowed 3 weeks to comply with the objections. Re-notify on.
24/7.
Same matter next. my lords.
Which one? The next one?
10 also, my lords.
10.
Huh. But the issue are not identical.
They're not identical, my lords. In the first matter, it's the case of subsequent purchaser having challenged the acquisition. In the second matter, my lords, it's not a Prabhu Kempegoda layout where a coordinate bench has already upheld the acquisition and has directed the landowners to go before a committee to be set up.
Same order.
Please, my lord.
Huh?
Please, my lords.
See,
Oblige, my lords.
11, 14%, Shri Krishnamurthy, Shri Y.N. Krishnamurthy, 14%.
My lord, IA number 2 of 2024 regarding the recalling order dated 2/4/2024, my lord. My lord, agreed by the order of the Learned Singer judge, I preferred a writ appeal. Writ appeal came to be admitted by its order dated on 9/6/2022. In the admitted writ appeal, whether the fresh inquiries are permissible in the absence of specific rule for the terminated employee, and without causing the fifth order of termination and also inquiry report which is pending for disposal in the admitted writ appeal, and also non-existence of relation between the master and the servant. Before deciding the issue on pleading, grounds and prayer of the admitted writ appeal, the Honorable Learned Singer judge had passed the order by extending 5 months time for the inquiry by its order dated on 21/7/2022. My lord, thereafter, the Honorable Division Bench passed the order that the inquiry may proceed and shall not pass the final order on the inquiry report by its order dated on 22/8/2022. My lord, thereafter, the respondent has taken undue advantage of the court order, conducted illegal inquiry without compliance of the procedure prescribed in the rule, and admitted that there is no rule for the terminated.
they have held the inquiry, but no final order has been passed.
Oh, my lord, now the final order has also been passed, then this, it was placed before this honorable division bench. Division bench, after seeing that the findings of the inquiry officer, they directed.
Permitted you to.
Permitted to pass the final order.
Which order is that?
That is the. Your lordship, kindly 8/4/24, I have filed one memo, my lord, detailing all the details, my lord. 8/4/24.
Yes, this order is there.
Yes, my lord. Here, my lord, that all this, what are the stages, my lord? In fact, my lord, this entire inquiry was monitored by the honorable division bench, my lord. They permitted to conduct the inquiry. Then they said inquiry proceedings. What is the development? Then ultimately findings of the inquiry officer has to place before the bench.
What is the penalty imposed?
Removal from service.
Removal from service.
My lord,
Just 1 minute. So this is a fresh order now passed.
No, fresh order passed. And in fact, that prior in this writ appeal is regarding challenge that order, my lord. It may not survive. The writ appeal may not survive because its first order has already been passed. And this.
What do you say, Mr. Murthy, about this submission?
But my lord, the filed counter application filed by the respondent is not maintainable and also misleading to the honorable court. It is not nowhere related to the admitted writ appeal. The order passed by the incompetent. And only thing is it is my submission. Kindly allow me to make submission finish within 5 minutes, my lord, on IA number 2. Then thereafter analyze what is the reality of the dispute, area of the reality of the conflict. So, my lord, thereafter, respondent has taken undue advantage of the court order, conducted illegal inquiry without compliance with the procedure prescribed in the rule, and also admitted that there is no rule for the terminated employee and also no statement of allegation pertaining to the charges and also witnesses. Before completion of the proceeding, the counsel for the respondent unilaterally filed an application, sought for permission to pass the final order in the inquiry report. For that, I filed a statement of objection to IA number 8 of 2022, prayed for reject the application filed by the respondent as it is not maintainable either in law or facts and divide of merit, and it is not a subject matter of the admitted writ appeal, and I have challenged only order of Learned Singer judge. I have not challenged the interior order passed by the extraneous subject matter of the admitted writ appeal, and it is out of pleading of the respondent. Then thereafter, the honorable division bench, without permitting me to start permission to make argument on IA number 8 of 2022, passed the order that the respondent take necessary steps pursuant to the inquiry report by its order dated on 9/2/2023. And further order that the party in person has not filed a statement of objection to IA number 8 of 2022. And though Honorable High Court has given the granted liberty, and he made only oral submission. Agreed by that order, I preferred a IA number 2 of 2023, sought for recalling the order dated 9/6/2023. Enclosed the relevant document, such as copies of order sheet and also copies of website, and acknowledgement of the statement of objection filed by the appellant, and also with affidavit, and deny the adverse remark made by the court. My lord, before deciding the issue on IA number 2 of 2023, during the pendency of the admitted writ appeal, in the coordinate bench, consisting one of the Honorable Learned Singh Judge, who had passed the conflicting and contradictory judgment, which is questionable in the admitted writ appeal, had passed the order that directed the respondent supply the copy of the inquiry report and final and penalty order, if any, it inviting 6th order of termination and inquiry report without deciding the 5th order of termination and inquiry report, which is pending for disposal in the admitted writ appeal. My lord, any order, either by issuing the termination order or removal order, can be issued only when the employee is in the service. When the employee is not in the service.
Well, as Mr. Murthy, but that would be only when you challenge this fresh order, no?
No, it is a 6th round litigations.
Right. But who would determine it? Will it not be a fresh proceedings and with fresh grounds?
No, the same matter. The same fact, same ground, and the same circumstances.
Right. But this plea of yours.
Yeah, that is a plea. It is.
1 minute. This plea of yours, that there is no relationship of employer-employee because you have attained the age of superannuation, they could not have removed you. That would be a fresh ground available?
No, my lord. My lord, the order of termination, the termination order has been quashed by the Honorable Court, and order for the fresh inquiry in 3/2/2012. And thereafter, if respondent wants to conduct a fresh inquiry or further inquiry, the charge sheeted employee has to be reinstated by placing under suspension for inquiry. That is as per rule. Till now, neither I was reinstated, nor placed the suspension for inquiry, neither provided sought salary from the date of quashing the termination order, nor sought providing the sought subsequent alliance. It is extraneous subject of the admitted.
1 minute, please.
Sorry.
We will hear you finally.
Yes, ma'am.
And any objections need to be cleared?
No, my lord.
All documents are there, no Kannada documents?
Yes, yes, all the documents are there.
Translation?
Another document.
You have to file translation.
My lord, 1 second, ma'am. It is my submission. The counter application filed by the respondent is nowhere related to the admitted writ appeal. It is extraneous subject matter to the admitted writ appeal.
We will see it, Mr. Murthy. What is extraneous, what is confined to the appeal? We will see it.
Yes, ma'am.
You will make your submissions. We'll hear you on that.
Yes.
But we want the translation of the Kannada document.
I don't have any objection, my lord, in this.
For what? For them
In
to
the
file
office
it.
objection, that is their objection.
You have filed it, you will file it.
Yes, ma'am. If it is not there, I'll file, my lord. I will-
You have not, we suppose you have not filed any documents which require
For
translation.
writ
No,
appeal
not,
filed by him.
nothing, madam. Nothing, my lord.
The counsel for the respondents to remove the objection. Who has filed this recall of 9/2/23? You have filed it.
Yes, my lord, I couldn't.
You have filed this IA 2 of 23?
Yes, my lord.
For
2 of
recalling
23 and 2 of 24. Both recalling order.
2 of 24 is recalling of which order? 2/4/24.
Yeah, 2/4/24 and 9/3 and by order dated, by its order dated 9/3/2020.
What does
23.
2/4/24 says?
before deciding the issue on IA number 2 of 23 and before and during the pendency of the admitted writ appeal, in the coordinate bench, one of the honorable justice who had passed the conflicting and contradictory judgment had passed the order directed to the respondent to serve the copy of the enquiry report and penalty order, if any. My lord, it invites a sixth order of termination and enquiry report without deciding.
We have seen that order. It's all right. Okay. To file the English translation of the Kannada documents at least 1 week before the next date of hearing.
My lord, I don't have any sources to meet the day-to-day explanation. My mother is admitted. She is suffering from multiple
File, my lord.
I don't have any shelter, my lord.
I'll only file.
Every day I'm struggling for the.
All right. When will you file?
Another 15 days, my lord.
Huh?
15
2
days.
weeks.
2 weeks.
Just list last week of July. We'll hear you. Last week of July.
Yes,
My lord, shall I file the written argument?
You file it. It would be good. You also file it.
Yes, ma'am.
Additionally, the counsel for the petition, the appellant and the counsel for the respondents shall file their written submissions
Yes. Much.
within the same time period. Next.
Serial number 12, Shri Mohan PS.
My lord, I appear for the appellant, my lords. My lords, we had filed an application for recall that has been filed with a slight delay, my lords. So the office had directed to file a IA for continuation of delay. If my lords may grant 1 week time, I'll comply and file the office.
The learner counsel for the appellant states that he shall file application seeking condonation of delay in filing the application for recall of order dated 14/7/22 within 1 week.
Within 1 week, my lords.
Within 1 week, re-notify on.
24/7.
Much obliged.
Serial number 13, Shri Nagaya.
Appellant in this case, kindly grant 3 weeks time to file LR's application, my lord. Respond number,
By LR, you have to cite setting of abatement, everything. you
please,
have
my
to-
lord, I will file everything, my lord.
The learner counsel for the appellant seeks 3 weeks time to remove the office objections. You have to get the notice issued to R5, R10, R12, R14.
I will take two dates of my
Just after 3 weeks. Let's give it August.
much obliged.
12th of August. Serial number 14, Shri T. Basavaraj.
Appellant today taken steps, my lord, regarding in respect of respondent number 3.
You have taken the steps.
Today, during the course, I pay the process.
Learner counsel for the appellant states that he shall take steps for the issuance of notice to respondent number 3
Yes, ma'am.
during the course of the day.
Yes.
Noting the said submission, re-notify on.
In the meanwhile, my lord, interim order today expires. my lord.
What is the interim order? You show me that. Interim order to continue
Much obliged.
till the next date of it.
Much obliged.
Till the next date of it. Yes, yeah. You have no clue. Yes.
Much obliged.
New date.
13th of August.
Just note the date.
13th of August.
Much obliged.
Serial number 15.
For-
Harvey.
Okay, for appellant is arranged on a week's time, we'll take fresh steps to the R3.
A week's time is granted to the counsel for the appellant to serve the respondent number 2.
Respond number 3, man.
Respondent number 3, sorry. Respondent number 3. It's to re-notify.
14th August.
Much obliged.
16. Serial number 16.
That in this case, I'm respondent party in person. There are 2 cases filed against me by one Indian Institute of Astrophysics, represented by the admin officer, Mr. K. Sripati. He has filed two different interlocutory applications for seeking contempt against me. One for filing one application under CRPC 197 CRPC, seeking sanction for prosecution of certain judges for their criminal acts. I've sought such application. Just for filing such application, I've been initiated contempt, claiming that I've made allegation against the honorable judges. I'll come to the fact why I have filed such a application. My lord, that is my fundamental rights for filing 197 CRPC application for sanction. I was a central government employee. During my tenure of service, I filed through proper channel that application. A copy was served to my office. Based on that copy, they have come before this honorable court to initiate the contempt. That is one case. That is criminal CCC number 7 of 2018. That is one case. Now in this case, my lord, entire evidence has been completed. During the course of hearing, the petitioner has claimed that during the trial, he will produce the evidences, witnesses to prove his allegation against me. But he has produced no witness at all.
Yes, one. What is the stage now?
Lord, the stage is commission was issued to the Registrar Judicial to hold evidence. Lord,
That's
he has
right.
some allegations against the Registrar Judicial. Now the Registrar Judicial is no more serving as a Registrar Judicial. The present incumbent is somebody else. So therefore his grievance is redressed. And therefore,
Is
Melody.
any case met? He made allegation against X person.
yes,
Person is no more holding.
no more
that.
holding that. So therefore the evidence could go on.
My lord, extremely sorry to apologize, interrupt. Actually, the learned counsel is saying about another case, my lord. That is another case, criminal CCC number.
Let's see the last order. No?
That is another case. Serial.
My lords, I appear for the complainant in the connected matter. My lord, CCC 7 of 2018, my lord. That is the connected matter, my lord. In that, evidence has already been concluded. However, CCC 8 of 2018, my lord, that is suo motu, we are not a party to that. In that, evidence is yet to be concluded, my lord.
But that's not listed, the other one.
16.1.
16.1, my lord, it's connected.
16.1.
One.
But
Connected.
in any case, evidence in 8 has to be completed.
Yes.
Yes, my
Yes,
lord.
my lord.
Yes, my lord.
May make a submission, my lord.
Yes.
Examination to be done before the registered judicial.
We will send it back to the registrar judicial.
Yes.
Now he's a different person.
May I make a
Yes, yes.
Lord, repeatedly, this honorable court is delegating this evidence recording proceedings to the honorable learned registrar. But the learned counsel, Mr. Anup, repeatedly harassing there, he is not coming before the court. He is not treating that registrar court as a.
How is this not coming relevant for judicial?
3 times.
1 minute, please. You will hear the
times
court.
he did
You
not
will
come,
hear
my
the
lord.
court, Mr. Dhananjay. How is that relevant? You have made allegations against the registrar judicial. He is not coming. How is it relevant allegations against the registrar judicial? You should not make allegations.
Not allegations, my lord. Fact, I'm saying.
1 minute, please. We'll hear you. Let the evidence be recorded by the registrar judicial. Okay? This previous registrar judicial has recused himself. So we'll send it to the registrar judicial. Very well. For the recording of the evidence.
What my submission is.
Yes.
Let the evidence recording be continued in this honorable court itself, because honorable court will come to know whether they are harassing me or that's all my.
You have any objections, you get your objection recorded.
Because learned counsel is not coming before court repeatedly. That's all is my humble submission.
How does it make, he's also. a
3-4
judicial
times
officer.
I've been coming
Now
there.
that judicial officer is not there. A different person is there. He has been transferred. Earlier one is not
I got
there.
it.
Then go there and let the evidence be recorded. There is an order to that effect already.
He was present on all the
Learned
occasions.
counsel has his own different grievances, my lord. He says that one application is pending, that has to be decided first before recording. So he is raising one of the other objections.
We will ask them. What is the issue on the application?
He files an application in between the evidences. Let a judicial states that should be brought before the court.
Who has filed? You have filed or he has filed?
I have filed one application.
What is the application for?
One application.
Section 311. and
1
again
minute,
summary
please.
in-
1 minute.
I filed one application seeking this honorable court's permission to call on record one very relevant direct eyewitness who has seen this entire proceedings. My lord, the allegation before me in this case is I have filed, made a forgery, prepared a objection, made a forgery signature of the advocate by impersonating that advocate, government advocate. Such a serious allegation has been made. I have not done such kind of things. But that counsel who has signed that objection, the very clerk of that advocate is no more, he is deceased. So one clerk who has seen the objection and he has written the complete in his handwriting, I'm seeking that the clerk has a witness to call before this honorable court for making my cross-examination. That's all, my lord. Because
That will be during your defense, no?
yes, my lord, defense, that's all.
Wait, first let the prosecution side be closed. Then we'll go for that, isn't it?
Yes, my lord, that's all. That's all.
Everybody should be done at the same time. How can it be? One by one, isn't it? First, let them let in their evidence.
That counsel is repeatedly making that same issue there.
See, let him do whatever evidence he has there, he will produce.
I have no objection. I have no objection.
You are entitled to cross-examine those witnesses
ma'am.
who are examined.
Yes, ma'am.
And when your turn comes, then you may summon any witness of your choice.
Okay.
Call the witnesses of your choice when your turn comes.
But counsel is saying,
This is not the stage.
counsel is saying, first my evidence should be completed, then he has to begin. That's his-
He has completed his part of cross-examination with regarding to the evidences placed before the
Things like that.
complainant.
Your side is over.
No, my lords, we are conducting the cross-examination of the accused.
ಯಾರ್-
He has completed, ಮುಗ್ದಿದೆ ಅವ್ರದಾಗ್ಲೇ.
He is the contemptor. It is the defense evidence.
Please, my lords.
Whether your evidence is over.
He sought permission from this honorable- We are cross-examining him, my lords.
You are cross-examining him.
Yes, sir.
Very well, we will send it back to the registrar judicial
Yes.
for that. Just take that.
After your cross-examination is over, then we will consider your application to call your witness.
Let's see, he has already filed his evidences, record, it's on record. We are cross-examining him upon that minutes.
Just 1 minute.
is me.
On 19/4/2024.
Let DW1 be over.
The registrar judicial. Before whom the evidence was being recorded as part the following order. It is a matter of record. The registrar judicial who was in place on 19/4/2024 has been transferred out and a new incumbent has joined the post as registrar judicial. And then if that be so, we list the matter before registrar judicial for further continuance of recording of evidence. Okay, in terms of the order passed by this court on 26/3/2020. Give the date.
Great question.
Do you want?
My lord, as soon as possible, maybe next. Another submission, in another case, I've already filed, with the due leave of this honorable court, I've already filed written arguments in the form of written argument, written submission. I will rely upon that for argument.
ಇದು ಮುಗಿದ್ಮೇಲೆ ಅದನ್ನ ನೋಡ್ತೀವಿ. After this is over, then we will come to the arguments.
I will just mention that I've made a written
We
argument.
first finish off that and then we will cut.
Grateful.
Just give the date. Take the date.
July, sir.
Sir, madam?
July most. 17, Jaikar Shetty.
I appear for respondent number 5, my lord. I made an application for early hearing. Some convenient date may be fixed.
All have been served, all the parties?
First,
Just show us the form. Who appears for 6? R6?
Nobody.
I appear for R5.
R6 served and under.
Is not appearing.
Not appearing.
Notice is served.
This is these two applications. No, this is an application for early hearing filed by the respondent number 5. The learner counsel for the appellant and the and appearing for 1 and 2, 1 to 3, 1 to 4. Has no objection with regard to the application being allowed. Suffice to state, despite serving, respondent number 6 is not appearing in the proceedings. Full stop. For the, in view of the submission made by the counsel for the appellant and the respondents 1 to 4, the application is allowed. The appeal is listed for hearing on. Counsel for the parties to file their written submissions along with the judgment they want to rely upon at least 1 week before the next date of hearing.
4 weeks.
31/7.
Please.
No Kannada documents? If
No,
any Kannada
they already
documents,
been
you have to find
it's
it.
already been translated.
Serial number 18, Shri B. Vachan.
kindly granted an opportunity to comply with the office objection.
Office objection, one of recalling of order.
This 622 minutes.
November 9th, 10, the same time.
Acha, okay.
Serial number
3 weeks.
9.
Same order,
Please, my lord.
3 weeks.
Please, my lord. Obliged.
When the counsel for the appellant seeks and is allowed 3 weeks to remove the office objections. Re-notify on.
5/7,
Obliged, my lord.
19. To Shauri HR. Serial number 19.
Lordship, appearing on behalf of appellant, counsel seeks 2 weeks of time, Lordship, to comply with the office objection. We have filed recall application, Lordship. To recall the order dated 15.
One day delay. For, yeah, what for it was?
Dismiss it for uncomplainant. Before.
Pending consideration of IAS. Pending these IAS, that's IA 2/123 and 1/23. And it is permitted to comply with the office objections.
Just say this, you are within that. Pending hearing of IA 2/23, IA 1/23. Now the counsel for the appellant shall comply with the objections as notified by the registry. We notify on.
Of August. Obliged. Serial number 20. To Sanjay
For
Krishna.
the appellant.
Finally heard for some time. Be louder.
This has to be finally heard. And last time it was heard for some time.
See what they say.
Yes, my lord, appearing for the appellant, my lord, there is an appeal and a cross appeal, my lord. Now, I am appearing for the home buyers before your lordship, my lord, for the, that is the association, home owners association. Now, my lord, the only question involved here, and it's a very short question, depends on the interpretation. Let me make one thing clear, my lord, the RERA authorities have passed an order which the appellate authority do not agree with. That's why they have filed a cross appeal. The subject matter is, my lord, the project was ongoing project. The project in question, which is called as Zenith Residences Apartments, which we are all owners, which we have bought, was an ongoing project on the day the RERA Act came into force. That is on 1/5/2017. Once it was an ongoing project which had not been completed, we go strictly by the RERA Act, which says, if you are on an ongoing project, and if you have not obtained a completion certificate stroke occupancy certificate, because in the north we call it as a completion certificate, here we call it as occupancy certificate, because in Karnataka there was nothing known as a completion certificate, everything was an occupancy certificate. Anyway, my lord, that was just a nomenclature. Now it has been clarified, the act has been amended, and so they said if you do not have a completion certificate or an occupation certificate as on 1/5/2017, you have to register the project, because the benefit of the act is meant for the home buyers. You can't deprive them, because there are certain forums created under RERA to which I can, as a home buyer, approach. The very object of the parliament enacting RERA Act was to protect home buyers. So, my lord, here what happened was, they did not have occupancy certificate as on 1/5, well, I'm just briefly coming and then I'll give the detail. 1/5/2017, they did not have occupancy certificate, admittedly, they don't dispute. They got occupancy certificate only in the month of December, by which time RERA Act had come into force. RERA authority had issued them 1 or 2 notices saying you registered the project under RERA. My lord, because it is a beneficial legislation to the home buyers, to the apartment owners. They did not register, my lord. So what we did as an association, we went to the RERA and filed certain, we have a lot of grievances, my lord, because under the RERA Act, for instance, under section 17, once the association is formed, you are required to hand over all the title deeds to the association. You can't keep it and further raise loan on that for some other project. It's not a continuous bank account that you can use my title for my project and you can go and raise loans. So the documents have to be handed over to the association. All original documents of title have to be handed. And this provision was introduced for the first time under section 17 of RERA. So we wanted to take benefit saying you hand over the documents to us. It is our project and we are now running the show. You have to cut the umbilical cord. You can't continue with the umbilical cord. Next question we raised, my lord, was all the common areas. My lord, there is a divergent finding by the appellate authority, my lord. What, just 2 minutes, I'll just briefly say and then I'll take it because, my lords, what another thing is all the common areas have to be handed over to the association. Common areas belong to the association. You can't hold the common area. Wherein the builder presently has filed a memo saying, I will not hand over all the things. The party area is mine, clubhouse is mine. My lord, that is on merit whether clubhouse is yours because he admittedly, according to even the RERA authorities in the first instance, he has completed a clubhouse or constructed a clubhouse on the common area on the car park. The land below are 3 phases car park. That's a common area. You construct a clubhouse on top of that. And then, my lord, the entire project was 4 acre, 20 guntas. He is not given the 6 guntas to the apartment. My lord, these are all things which had to be agitated before the RERA authorities, my lord. What he has done, my lord, now he is trying to interpret the section, your lordship may kindly see section 3 of the RERA Act. What is completion certificate? That is the crux, my lord. Because my complaint has been dismissed on the ground that he need not have to register the project under RERA. And all developmental work have not yet been completed till today. I have produced, my lord, day before, even last month, there are certain notices issued. They have to set up a substation, electric substation, which has not been set up, my lord. Till today, they have not done it. So this was the contention, my lord, on which, my lord, they said, no, he doesn't have to register the project. Because it doesn't have to register the project, your complaint is not maintainable. That is the ground, my lord. So we are now saying, my lord, that he had to register the project because the building was not completely, fully developed as required under the RERA. So to get over this, what he does, my lord, sometime in 2015, 10/10/2015, he has obtained one letter from his in-house architect. His in-house architect gives him a letter, who is a structural engineer, saying that this is the structure, so and so, you can apply. And based on which they applied to the corporation for occupancy certificate. Now they are saying the letter given by their in-house architect, that is completion certificate. The RERA authority accept, no, that cannot be, it has to be by a competent authority.
What is the certificate given by the architect?
He says that the building has been structurally perfect. That is not development work, and it has got nothing to do with the and he is not the authority to give a completion certificate. Because RERA Act defines who is the competent authority is defined. I'll take your lordship. It has to be given by a competent authority. And that he had given in 2015, which they attached along with an application in 2016, saying that you give us occupancy certificate.
Under which provision of law such a certificate is contained?
Under the building bylaws of the Karnataka building bylaws 5.6, architect, in-house architect has to give you, which is only a supporting document for you to attach along with your application to get occupancy certificate. And undoubtedly and indisputably, my lord, they got occupancy certificate only in December. We have produced it. And my lord, that certificate doesn't say that your development work is completed, and that's what the appellate authority says. That is not a certificate. That's why they have filed a cross appeal challenging that finding of appellate authority, which says that it is not a completion certificate or it is not given by a proper authority. It is invalid. in the beginning. Then what the appellate authority does, as they keep writing the judgment, my lord, they take a 360-degree turn. 360-degree turn, same judgment, earlier part they say it is not a document, it has got nothing to do, it is not a valid document. As they start writing a judgment, later on they refer to it and they say he has given a certificate and there is a inspection done, etc., etc. But you are not exempted under the act, my lord. Now this is the crux of the point. Appellate authority holds you have to register under the act. You have to, but you are exempted under one rule framed by Karnataka government. So they want to read that rule into the central enactment and say you are not exempted under central enactment, you have to register. To that extent, I have no quarrel. Karnataka government comes out with one rule, Rule 4, that is, my lord, for the benefit of the builders, the Karnataka government gave. Because the act is very stringent and very strict. Can you incorporate and import a rule of the Karnataka government into the central enactment and expand the scope of the act? That's what they have done. So you are not exempted under the act, but you are exempted under the rule. But that is illegal. You can't expand. That is also held, my lord, in 2024. Also, the Honorable Supreme Court, my lord, in an election matter where copies had to be given, there were rules, election rules. They said that you can't read it under the Representation of People Act Section 281. You can't incorporate a rule and import it into a rule and make things. I'll cite that, my lord. So, in broad perspective, what your lordships will have to consider is whether a rule framed by the state government under Article 254 of the Constitution of India is repugnant to the main act itself. But second alternative submission, which I would also like to submit is, my lord, even if we go by the rule itself, they have not complied with the rule. One, part A, a rule is repugnant to the act. Because, my lord, a central enactment, you can't yes. And under Article 254, one, my lord, it becomes repugnant. Whatever law you lay down, assuming it is not repugnant, let me give them a benefit of doubt. Even then, they have not complied with the rules which they have, my lord, they played a fraud with the court, and appellate authority in one breath says one thing and another breath, it says they take a volte-face, my lord, 360-degree turn, and they say, so we will not exempt you under act, but we will exempt you under rule. So I have challenged that question. They have also challenged that question. So both of us are before, broad perspective, my lord, both of us before that court. Now, my lord, if your options permit me to say, my lord, the act came into force on 1/5/2017, the RERA Act. Your lordship may kindly see that. Water to drink. The RERA Act. Take it down.
There is the provision for exemption under the act.
No, no exemption.
There is no exemption.
No, only 3. If a project is ongoing, if you do not have an occupancy certificate, they want to take advantage of building bylaws to get over the central enactment. Now the state government has, unfortunately for them, amended the Corporation Act also and says, no, there is no question of this. You have to, I'll come to that. Kindly see, my lord, Section 3 of the RERA Act. This is the only thing. Permit me to read, and this is the crux of the point.
Yes.
Yeah. Kindly permit me to read, my lord, Section 3, my lord. Well, I'll just go through Section 3 of the RERA Act. Prior registration, can I read, my lord? Your lordship's got Section.
Yes.
I'll wait. Your lordship's got it, my lord?
Yes.
Kindly, my lord. Now, kindly, I'll permit me to read, my lord. Prior registration of real estate project with real estate regulatory authority. I pause here for a moment. There is a regulatory authority which is going to protect me, and I want the protection under the regulatory authority. I have no other authority anywhere under any statute, any law who is going to protect me other than this regulatory authority. Therefore, your register is my prayer before RERA. My prayer itself is to register the project. Direct him to register. And they say, because it is not registered, act is not applicable. No, my lord. No promoter shall advertise, market, book, sell, or offer to sale, invite person to purchase in any manner, any plot, apartment, or building, as the case may be, in any real estate project, a part of it, in any planning area, without registering the real estate project with real estate regulatory established under the proviso. provided the projects that are ongoing, this is my case. I'm relying heavily upon this and only upon this. Provided the projects are ongoing on the date of commencement of this act, that is 1/5/2017, my lord, and for which completion certificate has not been issued. Completion certificate in this case is issued in December 2017. Therefore, I come squarely under this act is my case, my lord. The promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this act. And this is my prayer before the authority also. And my lord, other prayers I have made, which they didn't consider, that are not meant for this court to consider at this stage on merit. If my complaint is maintainable, let the authorities do their job. This court need not be troubled with doing the job of the authority, my lord. So they are refused to do their job. No, my lord, this is what is my case. Now, let me take your lordships through the Karnataka rules which came into force. Which book your lordship? Because this is the book code is there.
Realistic.
Rule number 4. What's that? Karnataka State R&D Rules 2017. If your lordships get that, otherwise I'll.
Yes.
Now, this Rule 4 was introduced by the state government. My lord, in my humble submission, it was to benefit the builders from not registering the project who had not got occupancy certificate. To dilute Section 3, this was introduced, is my humble submission. My lord, I may be right or I may be wrong, but that is my submission. But additional disclosure by promoter of ongoing projects. The word used is ongoing projects. This is an ongoing project, admittedly. Upon notification for commencement of subsection 1 of Section 3, promoters of all ongoing projects which have not received completion certificate shall within time specified in the subsection make an application to the regular authority in the form and manner specified in Rule 3. I have no objection with this, no grievance with this, is valid. Explanation now. For the purpose of this rule, ongoing project means a project where development is going on and for which completion certificate has not been issued, but excludes. Now, this is the rider, this exclusion, but excludes. Your lordships asked me, which is the exclusion provision under the Act? There is no exclusion provision, but here they introduce. But excludes such projects which fulfill any of the following criteria on the date of notification of these rules. So on the day when these rules have come into force, when did the rules come into force? Justly? 10/7/2017, these rules came into force, my lord. So from 10/7, this is the exception they want to give. You don't have to register. That is number 1. My lord, we can straight away come, my lord, to Roman 3. Roman 3 and Roman 4.
No, Roman 4.
Roman 4, my lord. Roman 4. They are taking advantage of Rule 4, Roman 4, which appellate authority says, I'll exempt you under Rule 4, Roman 4, but not under the Act. Act you have to register. Now, Roman 4, this is which is applicable to us, my lord, where all development works have been completed as per the Act. Means Act, we go back to RERA Act because development work is defined there. So until unless development is completed under the Act, RERA Act, this rule can't apply under the Act and certified by competent agency. Now, this is the crux. Who is the competent agency? And application has been filed with competent authority for issue of completion certificate, stroke occupancy certificate. Because, my lord, in some places in Karnataka, we did not have completion certificate, we had occupancy certificate. Because this is a pan-India act, my lord. RERA is a pan.
So reading of this, those projects would be excluded.
Yes.
Where all development works have been completed.
Yes, if it has been done, it will be. That is also, that's why I said, my lord, 2 alternatives. One is Such a rule runs contrary to the act itself, because there is no exemption clause there. Because it's meant for the benefit of home buyers like me, not to facilitate the builder. Otherwise, the parliament would not have introduced that act at all. Number one. Number two, I said, my lord, assuming this rule is valid, he has to satisfy clause 4 that all your development work was over. Now, what is development work as defined under this act, not under the Corporation Act and bylaws and all that? Who is the competent authority, my lord? As defined under RERA Act. Now, they have defined who is the competent authority.
So this completion certificate is given by the local authority?
No, it is given by the local authority, by the corporation. That is valid. I am not challenging the completion certificate, which is valid. It is given in the month of December, by time the act had come into force.
They're saying that even letter given by.
So what they are saying is letter given by my in-house architect, that is completion certificate. Under building bylaws, what my in-house architect had given, that is a completion certificate. My lord, now the question is whether statutory authority constituted under the statute who is empowered to give sanction plan and take care of the buildings, is his certificate important or your in-house structural engineer certificate is important? And that too given in 2015, and in assuming so, my lord, the crux of the point what the appellate authority missed here very badly is they had not completed the building because they had filed a writ petition here to ask for modified sanction plan after the act had come into force. So the writ petition number, and I'll give the order where they apply. Even that writ petition, they said, we have applied, asked for the corporation to sanction a modified sanction plan. That means your building was not complete. And let me take your lordships directly straight away to the occupancy certificate given by the authority, where they themselves say you have violated the building by law and you have to pay so much fine. Fine is paid only in December. Only after the fine has been paid, my lord, occupancy certificate comes into effect. So no private in-house architect can get over all this. Kindly see, my lord. Let me take your lordship through the paper book, my lord, to the occupancy certificate, which I don't dispute. No, appellate authority seems to think I'm disputing occupancy certificate. No, I'm not. We'll go there. We'll take next step. Occupancy certificate. Page 252.
Yes.
My lord, straight away I'll take your lordships to the
There I have all the definitions you'll have to start with.
First, number certificate. 240. 240.
Mr. Anand.
Yes, my lord.
To our recollection, this issue is also raised in some other petition to our
Maybe.
recollection.
I'm not aware, my lord.
No. We were just only thinking, shall we have it on that day so that we can have the-
because let
have
there
the
be,
benefit of hearing all the councils.
let there be no repetition for your lordships also, my lord, and let there be no conflicting and
That's
contradiction.
right, so that we'll
I
have.
have no
the benefit
objection.
of Hearing those.
I have not, my lord, since the matter is listed, I didn't want to ask for an adjournment, so because I should be fair to the court, I didn't want to. Lordship fix it on someday at 2:30, my lord, would be.
How long you would take?
My lord, I will, if I can convince your lordship, my lord, it should not
Last
take more than.
occasion, he argued for 2 days, so it will take some time.
If I'm going to make the submission, so in my opinion, in my knowledge, I can convince the court within 1 hour, that's over. Because the small question of law. I'm not going to take your lordship into facts. Because your lordship is not called upon to decide facts here now at this stage. We are in a second appeal. Only question of law. If your lordships hold, no, the rule is valid and they have complied with the rule, I have no case.
At least we made a submission. Easy issues ಮೇಲೆ ಮಂచి good bench. You have numbers?
See, to our,
ಇದೆಲ್ಲನೂ ಮಿಸ್ ಮಾಡಿ ಅಂತಾನೆ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು ಇದನ್ನು ಅದನ್ನು
we have been told,
ಅದು ಸೀರಿಯಾಟರ್
we have been told we have fixed third week of June. Those matters.
Same on rule 4 only.
On rule 4 only.
So they're already in third week of it.
ಅದು ಬಂದಿಲ್ಲ ಈಗ.
July 3rd.
July 3rd. July. Because they're already in third week.
That's right. We'll have it in third week of.
No urgency, we have no.
We will not, possibly, we were giving an fixed date, we will not say so. So that possibly it may coincide with the listing of those matters.
We are ready. In case we require 1 day or something accommodation, we may say that because we get ready in the matter.
Only one request, possibly brief note of submissions, any judgment you want to put it on record, please put it on.
We have kept it ready.
Possibly exchange it, that would be.
Because my colleague is doing it, could not come because of some passage and we got dead. And another submission for this matter was also under the Honorable Supreme Court in the case of West Bengal, West Bengal came out with the act which is called as GIRA, where it was conflicting to the RERA Act and that act was struck down by the Honorable Supreme Court. On these very points on which I am practically.
Possibly ultra virus to the main act, that would.
Exactly. Exactly. So that is, so I don't know, come back.
We notify these petitions in third week of July.
Third week, 15, no, 15.
The council for the parties to file their brief note of submissions along with the judgments they want to rely on. 1 week before the next date of court.
But some other issues are also there, Milord, not on the.
Whatever you did, that's his perception of the matter.
His argument is this completion certificate is not in existence, only occupancy.
That is applicable for ABC reason.
Yes, sir.
I'm making only one short point, that's all.
The distinction with regard to completion certificate and occupancy is there in the act itself as well as under the Karnataka Municipal Corporations Act.
It has all been amended, what that document is amended, now is amended. It's been amended, what is the.
AMC Act is
Okay,
there.
thank you.
Third week on the. The lordships are giving any specific date, Milord?
We, in those matters to our information, we have said third week of July. So we, so that possibly we will see in 1 or 2 days, if those matters have come, we will possibly list it along with that.
Very well.
No, no. Wait, continue. ಏನಾಯ್ತು? ಅದು ಬಂದಿದಾ?
Serial number 21, Sundar Rama.
So I'd like to appear for the respondent number 2 and 3, my lords.
What happened on the last date?
That's a final notification.
That's right.
My lords, the preliminary notification is published. He's been issued a notice to state his objection in as much as the acquisition is concerned. Now, my lords, I'm sure this honorable court in all magnanimity will give him an opportunity. I'll only make out my case, my lord, with the deepest of the apologies. My lords, as a recorded order before this honorable court, we propose to give without acquisition half of the agreed compensation. The check was handed over to him, my lords. in the open court. It was noted, it's a part of an order. I'll read it out. Now, my lords, and he was asked to come and give an undertaking before the KIDB that he'll receive the compensation, and he wouldn't, because it's already allotted to someone else. The claim is only that it is his land. We are not disputing that. Incidentally, my lords, he doesn't file the required memo before the registry. On the contrary, he goes and returns the check to KIDB saying that he doesn't want the compensation. Now, that is when my lords left with no other option. I'll have to acquire it through a process. So I have already now proposed the preliminary notification. When we made submission on the last date of hearing, my lords, this impending elections for about 3 months, there was a code of conduct due to which we couldn't issue a notification as such. Now, my lords, he has to state his objections to the acquisition. It is already acquired. At some point in time, he accepted the compensation. Nevertheless, he refused it as on this day. So, my lords, the notice is already given to him. If he comes and appears, or even for that matter, states before this honorable court that he has no objection to the acquisition of that 24 guntas, which is disputed, which is allegedly taken without acquisition and handed over to some other beneficiary of the acquisition as such already. So, my lords, if he states his objection, we could immediately pass the final notification. Without his objection, I wouldn't be able to issue the final notification.
Did you issue the preliminary notification?
My lords, preliminary notification is issued on 7/6/24, my lords. 7/6/24. I can give a copy of that as well. 7/6/24, my lords. And as on day before yesterday, my lords, we have also issued him a notice calling upon him to state his objection. If he orally even states here also, my lords, this is 7/6/2024 is a preliminary notification. After this entire process of taking compensation, refunding it and giving it back to us, all of it failed. He has rightly given us the check back and we have it in our possession. We are not disputing that. So, my lords, will acquire it. Inasmuch as, my lords, the entire extent is concerned.
He would definitely, on the notification, he will put his objections. Do you intend to put it your objections? Will only record this. You have issued a preliminary notification on 7/6/24.
Let him, a date may be fixed, my lords, now that he is aware that it is being heard. If a date is.
You have already occupied the premises. You have given it to somebody. And what kind of objection?
That's exactly that. That is why we offered to give him 50% of the compensation. Check was handed over in the court without acquisition itself.
5 crores something.
No, my lords, that was an earlier one for the other 2 acres, which is not disputed. Now, what has happened, my lords, is a very intricate issue here involved. If my lords were to see an order of this honorable court, earlier order, the whole thing will suffice. Order dated 22/10/2020.
22?
22/10/2020. What happens, my lords, is we notify about 6 acres and those lands are denotified under relevant provision of the KID Act Section 4. During that time, my lords, the engineering section builds a road right in the center. And then he approaches this honorable court. Having realized that we need it for the road, we notify it afresh once again. That preliminary notification is challenged before the learned single judge of this order. We make a submission before the learned single judge that it's a premature writ because it's only a preliminary notification as on this day. It is dismissed. He carries that order in appeal before these proceedings, that is in these proceedings. Here, my lords, it is brought to our notice that without the final notification, the road is made already. At that point in time, we tender our apology to this honorable court. This honorable court says, in as much as those 2 acres is concerned where the road is already made, you immediately give him compensation. For that, we give him 5 crore compensation. He accepts it on a consent mechanism. After that, my lords, he comes and says there is another 24 guntas which they have occupied and they have given it to someone else. For that, my lords, the dispute is. And in as much as the entire 5 acres is concerned, we have already issued final notification. Now, only 24 guntas where we have to issue the final notification, we'll issue it in a time-bound period as long as he comes and appears, my lords. There is no dispute as regards that.
Correct. 24 guntas, you say that it has been acquired. They are already in occupation, given to somebody else. And what kind of objection you have for preliminary notification? He has to issue. You say,
Let me make a statement before this court, my lords. I'll pass the, as in we'll endeavor to pass it within 1 week or 2 weeks as my lord sees it.
Notification.
Please, my lords. Because if he stated his objection, then no formality remains for me to hear him. He has to first state the no objection, my lord.
Shall we say this? That preliminary notification issued, you don't want to file any objection, let them pass a final notification.
24 guntas only.
Obviously, it has to be. Do you say so? We'll record it. No.
You file a memo, that is where, give it.
All the more.
And on that basis, let him go.
File a memo. Give the- just-
With an advance copy to us, my lord. Sir.
You will only say you have issued a preliminary notification.
Please, my lord.
He has no objection to issue the final notification. You
Yes,
proceed on that.
Based on that, we'll
The on the last date of hearing, the senior counsel appearing for the respondents 2 and 3 sought 2 weeks' time, sought an adjournment of 2 weeks. Today, Mr. B.B. Patel, the counsel appearing for the respondents submits that the respondents have on 7/6/2024 issued a preliminary notification in respect of acquiring
24 guntas. only.
24 guntas of land.
Please.
The learned counsel for the appellant submits that he intends to file a memo seeking a direction that the respondents 2 and 3, no?
Please, my lord.
Respondents 2 and 3 should issue a final notification. Full stop. He states that the same shall be filed within how much time? Within 1 year.
Your memo. Today. Today only you are going to file.
File it during the course of the day. If that be so, list this matter next week. You file your memo, we will set the timeline.
Yes.
Without, we want something in writing, what
Yes.
you say,
Please.
okay?
Yes. Deeply obliged. Deeply obliged.
Next week.
Obliged. Obliged.
Yes.
Serial number 22, Sanjeev BL.
What? What was the charge against him? Charge was, he involved in an accident. Now, what happened? What was did the person suffered any injuries? What was died?
Two bits.
To notice. Slightly louder. You have reinstated him. Oh, you have reinstated him. So what have you not paid? The continuity of service and back wages. So we will only say so. But then tell us one thing, then how can you contest the back wages? Would not be entitled. So what remains in the appeal? Obviously, he will get it. You can't, see, let's be very clear. You have reinstated him. The consequence must flow. Otherwise, if we were to ask you, what would be the date of reinstatement? Then, see, back wage is not given, continuity given. Obviously, it has to be that way. No, then we are.
But then, now they are.
Have you said so in your petition, in the appeal? Yes, show us that. Did he file any execution? No. You did it yourself.
Now, after reinstatement, now again you are challenging that.
Avoid what? But you were there before this court. Then why didn't you pursue this petition appeal? Now tell us one thing. Let's assume for a moment we were to agree with you. Are we to say direct them that he should be taken out of the service? That's the earlier one.
No, I think in the writ petition you have stated, in the writ appeal, correct, in writ appeal you have stated that the dismissal was proper because some other earlier accident, past history was also there, which he had not intimated about the accident. But this aspect was not raised either before the labor court or in the writ petition. Not in this. See, in appeal, you are in appeal memo. In appeal memo, you have stated
To tell us one thing, as an employer, such serious charges, you want to reinstate very well. Because obviously, a reinstated means reinstate. Means a part of the order of the learner single judge has been implemented. See the bottom of this. Requested to get the stay against the order passed in this, except reinstatement and intimate to this order. So, very well. So reinstatement, they also agree, they take it. He is reinstated. Now what remains? No back wages, continuity. Now continuity has to be given. You can't treat him as a fresh appointee. That you will impose. That you will impose. three increments, you will do it. We are dismissing it, we'll say so. Which portion of the award? Which portion? C is obviously, the further matter, petitioner would not be entitled to 3 annual increments. See, that's the deterrent, you know, for the act he has done. See, possibly we were with you, but if you have reinstated USL, what can we do? Tell us. You have done it, and we were very clear. The challenge in this appeal is to an order dated 23rd November 2021, passed by the level of single judge in bid petition number 55775 of 2017, whereby the learned single judge has set aside the award dated 23/8/2017, passed in ID number 33 of 2015 by the Additional Labour Court, Bengaluru, and thereby directing as under page 12, small Roman 1, 2, page 12 and 13, just read. At the outset, the learner counsel appearing for the appellant corporation has placed before us a communication dated 24/1/2023 from the Chief Law Officer to the Divisional Controller, KSRTC, Bangalore Central Division, Bangalore, a copy of which was addressed to the council, wherein the following has been stated. A perusal of the same would reveal that the respondent, that the appellant has reinstated the respondent herein. He is subject to writ appeal, but why we will not take into consideration that particular aspect to decide your appeal? You have done it yourself. That's the reason we have asked you, was there any execution petition? On the threat of execution, you have reinstated him. You said no. Then you have done it yourself. Obviously, it has to be that way because you filed an appeal. What did I say? As the appellant has reinstated the respondent workman into service. On a specific query to the learner counsel for the appellant, whether the same has been, the order of reinstatement has been passed because of any execution petition filed by the respondent workman, the answer is in the negative. That would reveal, and that would show that the appellant themselves, the appellant itself has reinstated the respondent in service. The only issue which arises for consideration as contended by the learner counsel for the appellant is that the learner single judge, while setting aside the award, has directed that the respondent shall be entitled to continuity of service and consequential benefits pursuant to reinstatement. Pursuant to reinstatement. This, according to him, is that the learner single judge has not granted any back wages to the respondent. Tell us one thing, just let me sit down. Tell us one thing, what was the date of dismissal? Okay. Yes, okay, come in. As learner single judge has not granted any back wages from the date of dismissal, that is 28/5/2015, till the date of reinstatement. If we are not in agreement with the only challenge made by the learner counsel for the appellant to the order of the learner single judge, wherein the learner single judge has granted the continuity of service in favor of the respondent. It goes without saying that if the appellant has reinstated the respondent, the necessary consequence is the respondent shall be entitled to continuity of service. As for all purposes, his service shall relate back to the date of dismissal, that is 28/5/2015. In the facts of this case, more particularly, when the appellant has reinstated the respondent, we are not inclined to interfere with the impugned order in exercise our in the facts of this case. We take it on record, this letter. Just give a photocopy of it. The same is taken on record. Very well, we'll say so. The learned counsel for the appellant has also urged that the learned single judge, as in small Roman 2C, stated as under. No, 2C, which we have reproduced above. A perusal of the same would also reveal that the learned single judge has, as a measure of punishment, directed that the petitioner, that is the respondent herein, would not be entitled to 3 annual increments with cumulative effect from the date of dismissal till date of reinstatement. The effect thereof is the same shall act as a punishment for the misdemeanor committed by the respondent. Even this plea of the learned counsel for the appellant does not appeal us. The appeal is being without merit, dismissed.
Twenty-three, Shri Basuraj, H.T. Basuraj.
What is wrong?
Where is this scheme here, the rules, what is that rule? People will compromise saying that where is that rule, this voluntary surrender of land rules? This notice, this notice as well. We'll issue notice.
Notice for respond number 6.
What does that rule say? Have you annexed it? You appear for whom?
I think for the respond number 6 state.
Where is state here? State of Karnataka. 5. Applications.
To notice on appeal as well as the IA number 1 of 23. 2, the respond number 124.
22.
23.
Give a date, returnable date, say August, September. Go on. Yes, next.
Serial number 24.
Accused, my lord. This is criminal contempt proceedings being initiated, charges were framed and complaint was examined and cross-examination also done. Now it is for accused to depose evidence. I am appearing for accused number 123.
Who is recording the evidence? Registrar Judicial?
Complainant, no, here court only recorded.
We'll send it to Registrar Judicial for recording of evidence.
Please, my lord.
Now, what is the stage now? Whose evidence, whose statement?
Accused evidence, my lord.
Accused evidence. See there?
Yeah, accused is present, my lord. Accused number 1 and 2 are present. Accused number 3 is a company represented by again 1 and 2.
What is the nature of allegation?
Interfering with the administration of justice by filing false cases, my lord. That is the allegation based on which the trial was directed.
ಅದ್ರಲ್ಲಿ ಯಾರು ಇದರಲ್ಲಿ KL Renuka, KR Krishnamurthy lawyers.
No, subsequently, by virtue of coordinate bench of this honorable court, state has entered into the complainant shoe. Now complainant is represented by state.
SPP ಎಲ್ಲಿದ್ದಾರೆ?
If your lordship permit me to file affidavit, I will file the affidavit for the chief examination is concerned.
Chief, you file an affidavit, but
Cross-
cross-examination need to be done by them. Their evidence is over,
Their evidence is over. Complainant side evidence is closed.
close. None for the.
Complainant.
None for the.
SPP
None for the complainant, we have
and
been
he
informed.
is SCGP. AGA. AGA is there, who is representing them. He doesn't.
We have been informed by the learned counsel appearing for the accused that the evidence on behalf of the
Accused.
complainant.
All the accused.
Complainant has been concluded. Full stop. He states that the accused intends to file affidavit as an examination of chief.
By accused number 1 and 2, my lords.
How many are there?
Other 7 accused were there, but I am not representing them.
What would happen to others?
They are not present, even nor the advocate.
Their cross-examination by the prosecution or by them has been concluded
No,
for seven.
It is only by accused number 1 and 2, my lord. Cross-examination is concluded by.
No, they were present, isn't it? All these accused, all accused were present. Today, all accused are present.
No, only 2 accused, accused number 1 and 2. 3 is a company again. It is represented by accused number 1 and 2.
You are Malangowda.
Yes, my lord.
And what about the other accused? Have they been cross-examined?
No, my lord, they have not conducted any cross-examination. But cross-examination,
See, better we will, before we pass this order, let's have the complete proceedings.
please, my lord.
Who is accused again, whether they are on bail?
To the stage.
You are for accused, you are 1 to 3.
1, 2, 3, my lordship. There are other 9 accused. Out of 9, 2 were dropped. One is advocate and another one is also dropped.
4 and 9 have been dropped.
No, 9 and
4 and 9.
4 and 9 have been dropped.
For the AG appears for the complainant. No, but SPP office. And for the complainant, we find that only accused number 1 and 2 are present in person. From that apart, we also find that accused number 4 and 9 have been dropped. The other accused are not present. Let available warrants in the sum of rupees 20,000, 50,000 be issued for the appearance of the other accused. That is 2, 5.
3 ಗೆ ಬರ್ತಾರಾ?
no, my lord. 1, 2, 3 present.
2, 3 are present.
1 and 2 represented by 3. 3 is a company, my lord.
So it would be 5,
5, 6, 7, 8.
5, 6, 7, 8. Returnable on. 3,000 each.
Please.
31st of August.
Serial number 25 adjourned, 26. TPD Surana. 26. TPD Surana, Sri Nagarajas. 26, sir.
Serial number 26 appear for the applets, madam. Pray for 2 weeks time. 26. Serial number 26. So Surana has ended up in quote number 1.
Sir, Tavyarigi, sir.
PD Surana, applets.
Therefore, appellate. Seeking adjournment.
Yes. You are for the appellant.
It was remanded. On the ground, that the sale challenge in the race.
What, is there any stay of the impugned order? Is the stay there?
No. It was there, but I think it was not extended. It's 7-9. It was there, but later it was.
At the request of counsel for the appellant for an adjournment, we notify.
Second, 27.
ಇನ್ನು ಮುಗ್ದಿಲ್ಲ.
27, Sri Chandrasekhar.
Appearing for the appellant in that matter, madam. Huh? Appellant. ಎಲ್ಲ appellant ಆ ಕಡೆನೂ ಇದೆ ಈ ಕಡೆ. So. And one of the appellant is dead in appeal number, my lord, 27.3, my lord. I think my learned friend, Mr. Manmohan appears in that matter. I think that can be allowed, my lord, because
Which one? Is an LR application?
Yeah. Now it's there.
What has to be done? All
That
this
can be
has-
allowed, Manoj. LR application may be allowed with the consent of the parties. Manoj. I mean,
And show us the file.
Yeah, 27, 1146,
writ appeal number 1146 of 2022.
27.6 ಕೊಡ್ಬೇಕು. That is not the file, I think. ಹೇಳ್ಬೇಕು sir.
Yeah, copy there. Good. Can I give the copy? One 1146 of 2022.
IA copy.
Photo officer, IA copy ಕೊಡ್ತೀನಿ. IA.
Ultimately, this is totally dependent on another writ appeal which is pending in.
Yeah, absolutely. Your lordships are absolutely right, my lord. Connected is in Dharwad High Court. This judgment that is connected and listed also before your lordships.
It's now.
It is
part of
also
this.
Now part of this.
ಇಲ್ಲೇ ಇದೆಯಾ?
Illa ಇದೆ. Yes.
In those cases.
So yeah. ಎಲ್ಲ list ಆಗಿದೆಯಾ?
ಇನ್ನ ಎಲ್ಲ ಆಗ್ಬೇಕು.
Answer your by.
Beneficiary declare ಆಗ್ತಾರೆ. ನಮ್ಮ ಕೆಲಸ ಕೆಲವು ಕೆಲಸ ಹೇಳಿದ್ರು ಗೊತ್ತಾಗ್ತದೆ.
By which order those matters were transferred here? Which is that order of the Honorable the Chief Justice?
Administrative order. ಆಯ್ತು ಇಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ ಅಂತ.
Hello. No.
ನಂಬರ್ಸ್ ಕೊಟ್ರಲ್ಲ ಅದನ್ನ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಅಂತ.
Code officer.
If an award is passed, not passed as of 1/12/2004, and it within 1 year, based on the fact that the proceedings are future. Now that the tenancy that is other without the statute of 2000. On the ground that the 1894 was a total and repeat bar. And a new comprehensive act has not. Therefore, a new act has to be taking into consideration the benefits to the
is all. During the pendency of the petition, the act has been, there is a deemed provision, issued that as part of 2039. The short question is that these deemed provision would affect from 1/1/2015 or from the date on which Karnataka Act 20 of 2035 or 2020. This is a short question. And this question has now the answer from the executive engineer stating that if a new act is applicable, from the date on which 1/1/2015, but prior to that, if new act is not applicable, there are two kinds of our system. The same reason is not
That will be on merits, my lord. In the meantime,
Service computer.
There are different categories of cases. All are not like this. There are.
And you are asking and list all the matters together. Anybody can come on market without various matters of pending. That's my appeal to you.
Some appeals, acquisition is over, award is passed before the new act came into force. So that's also a question which will arise.
When the law has been substituted, whether it's incorporated or not, the substitution by Act 20 of 2019. The replacement has been allowed because the law extended substituted. The new law will be directly applicable.
well, we'll argue.
But the language is as if you are reenacted regarding their arm. That means 2039.
Who are the, in which appeals the parties have to be served?
My lord, in appeal, I think.
No, we will not go by individual response. We will say the unserved respondents be served. Please.
Can I request, my lord?
The appeals.
Can I request, my lord, let them serve on the council would appear before the learned single judge so that it will be easier, my lord, other the process.
I know,
In
Mr.
addition, my lord.
In addition
To that, so that, if.
That's right.
Yes, yes.
Yes.
Yes, give it. But whether,
But-
whether the special order has been passed by the Chief Justice on that.
That we have to see.
If submitted, they are,
That's not
they're straight.
That those cases are very different. Open to the law, majority is important to the council. Then they can mention.
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿದಾರಲ್ಲ. Anyhow. ಅಲ್ಲ, the matter same. ಅಲ್ಲ, same subject matter is there ಅಂತೇಳಿ Mr. DLN Rao is already submitting it. ಈಗ ಉಳಿದವ್ರು ಯಾರು ಹೇಳಿದ್ರೆ ಅದನ್ನ ಬರ್ಕಂತೀವಿ, ಹೇಳದಿದ್ರೆ ನಾವ್ ಹೆಂಗ್ ಬರ್ಕಂತೀವಿ?
In which matters the respondents have not been served? In which matters the respondents have not been served?
27.8, sir.
27.8.
8 not so.
Then. No, all appear in 27.5?
Yes, sir.
No, only just tell us where they have to be served, the respondents. That's in between the council, you just call him and take a count. Now, 27.8 we can see.
Yes.
R2 has to be served.
27.11.
9 also, my lord.
9 also.
10 also, my lord.
Yes, 10 also.
11 also, my lord.
Pardon?
11 also. my lord. 30.
Who has to be served in 11?
I think landowners, all landowners, please. Landowners, please.
No, but which respondent?
Or 125, 1 to 5. 27.11, 1 to 5.
Just say this.
And if you consent a word, you along with them, you file a joint memo on that aspect and then we will delink and dispose it off. What is that? Why we should break our head? He can.
Just take down. The unserved respondents in this batch of appeals, we served within 4 weeks. Full stop. We had, during the course of hearing, we have been informed that 3 writ appeals pending before the Dharwad bench, being so and so, have been transferred to this bench of the court. Full stop. According to Mr. D.L.N. Rao, senior advocate, only 1 appeal being so and so has been listed along in this batch of appeals. He requests that the other 2 appeals, despite order of the Honorable the Chief Justice, have not been listed, be also listed. The registry, if there is an order of the Honorable the Chief Justice on the administrative side, shall list those appeals along with this batch of appeals on the next date of hearing. Counsel for the parties shall file their written submissions along with the judgment they want to rely upon at least 1 week before the next date of hearing.
No, there's number of Kannada
27,
documents are
as
there,
your
but
IA.
they will have to translate.
That is in my lords, my learned Mr. Manmohan's appeal, my lords. Writ appeal number,
The counsels appearing for the appellants or the respondents shall ensure English translation of the Kannada documents are filed before the next date of hearing.
insofar as 27.6, my lords.
IA 2/24 allowed. That's of the appellant permitted.
Is that so? 1 of
27.6, IA 2 of 24. This is appellant.
This 2 and 24, just take 2 and 24. This is an application filed by the loss of the applicant, number 3, for bringing them on record. The letter counsel appearing for the respondents in this appeal have no objection if the application is allowed. Just show us the application. 27.
Serial number, filed in serial number.
27.5.
Accordingly, the loss of the deceased
Number 3.
appellant number 3 are brought on record. Let necessary correction be made in the amended memo of parties. Additionally, an amended memo of parties shall also be filed by the counsel for the appellant number 3. Application disposed of.
Can I make one other request, my lords? Can I make one other, serial number 27, 27.2 and 27/3, my lords? We have filed an application for dispensing the annexes which were produced before the learned single judge. Because again, the same, my lords, 27.5 also arises out of the same matter. They have already been produced, my lords.
Already on record.
Already on record, it will just be unnecessary.
Which is that application, Mr. Shetty?
That is application now,
Said 27.
27.2 and 27.3. Yeah, 27.2 and 27.3.
Just take down. This would be
That is IA 1 of 22 in both.
1071, 1064,
1 of 22.
IA 1 of 22 in WA 1064 and WA.
Even 27.1 also says so.
Yes, madam. 27, that is 27.1 That's the first matter, my lord.
27,
27.2,
27.3.
3.
Let it be on record, Mr. Shetty.
Please.
We look into 27.5.
Fair enough. Please, my lord. Please. Let it be that you don't have to.
Wherever there is interim order. Interim order granted earlier is extended till the next date of hearing. In all the matters. Pardon? The same, man. The same interim order, if any, granted earlier, is extended till the next date of hearing. In the batch of appeals. Yes. Doesn't make any difference.
It makes no difference. If it is there, it is there.
You will rely upon further orders.
Whichever is beneficial.
Whichever is later.
Late, just give us after 4 weeks, 5 weeks.
Please. Grateful.
Pardon? We are, listing the matters accordingly so that we can take it. Let's see. Which matter, which number?
ನಿಮ್ದು ರಿಟರ್ನ್ ಇದ್ರೆ ಹಾಕಿ ಅದರಲ್ಲಿ hear the matter.
Same questions are
If
involved.
same questions are involved separately, how can it be? Correct. We can't help that. See, common questions are there. There are so many battery of lawyers who are appearing, and you say that mine is different and you decide it mine separately. How can it be? See, when they are taken up, you argue your point. In all these matters, same question is involved, isn't it?
Yes.
Or you beg to differ?
Same question. Same.
Correct. You argue that also.
We have taken the numbers, right? Numbers of the appeal which have been transferred to the bench.
Yes, you have taken. Yes. Yes.
Three. You say now only 2 have been given. Which is the one which is listed from the Dharwad bench today before us? Which is the one which has been transferred, Mr. Rao?
Yes, sir.
Which has been listed from Dharwad bench here?
Yeah, 3 of them, my lord.
No, there are 3 of them.
Serial number.
One is listed.
Serial number.
The number, sir.
27.9.
Just note down.
Other 2 writ appeal numbers I have given, sir.
Yeah.
ಅಲ್ಲ ನಮ್ದು ರೀ ಮಾಡಿಸ್లేదు.
Yes.
This arises in the same info law.
Number 2, serial number 1, Srimati HR.
My lord, this may be passed over the learned counsel.
Just one.
Yes.
Yes.
My lord, serial number one, the counsel for the appellant is held up in another court, but she's ready and I'm ready as well. So if it may be passed over, my lord.
Pass over. Which item?
Serial number one. Serial number two, Sri Gaurav Singh.
This, I think, we may have to. This. So what it is, we have that adjustment, etc. Data.
He has unlimited. He has limited to 10 lakhs. In some cases, it may be nothing. Yes, this falls.
Serial number 2, Shri Gaurav Singh Gaur.
Page number 33 of the order part is single, that is very clear now. Page number 33. So far as the application of the petition that there will be rendered job suffice it say under clause 8 of NIT, the successful bidder has to appoint a local photographer compulsory after imparting them necessary training. Therefore, the opposite apprehension of the petition is baseless. In view of the proceedings analysis, I do not find any merit in the writ petition. The same case will be dismissed. This is the appeal filed by the photographers union near Joke Falls.
What remained tender was for how many period? What was the tenure for the tender?
3 years.
3 years are over. Oh, long back.
The tender has been,
You have issued a fresh tender.
no, madam.
You are continuing.
No, madam.
No. They have
They
this.
challenge that the AC has no power to issue a tender.
Right. But this tender which you have issued in 17,
Yes, madam.
have you given to anyone?
No, madam. Till now we are not going to anyone because due to stay.
Oh.
That is the problem, madam. If the petition is disposed of or dismissed, we'll take necessary steps to issue a for new tender and it will be helpful for the and
Investigation.
page number 109, page number 109 of the opinion memo.
But just 1 minute. So for attention, there will not be. We'll just pass over.
Serial number 3, Srinivas V.
Circular dated 26/2/2008.
You appear for the state.
1, 2, 3, madam. Please register, let me check out and
Final hearing member. Final hearing member. What is the under final hearing?
check my.
Procedural.
Yes.
Three, what is our four, three year one. Government head. Four go ನೀವೇ ತಗೋತೀರಿ sir.
I'll check it out in the office and if there is, if any standing council is there, or else I'll check it out.
R 1 to 3 ಗೆ ಇದೆ.
1 to 3 now.
4 ಗುನು ನೀವೇ ಹಾಕ್ತೀರಿ ತಾನೆ. ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರು.
Sometimes in the rural side there will be a standing council for them. It is not on the page.
Or assistant registrar cooperative society. Deputy registrar you are appearing.
Yes, ma'am.
Then assistant registrar also you are representing, isn't it?
Yeah, assistant registrar is under deputy
Deputy registrar.
Sometimes there will be a standing council for that, to that effect. That is,
ಹೇಳ್ಬೇಕು.
or else a week time maybe that I will check it out. If it is not there, I will take the notice. A week time maybe that let me inquire in the office and
ಏನದು ಸರ್ಕ್ಯುಲರ್ಗೆ ವೈಲೇಟಿವ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಏನ್ ಹೇಳ್ತೀರಿ?
next Monday.
ನಾಳೆ ಹೇಳಿ. ಅದ್ರೊಳಗೆ ವೆರಿ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಈಸ್ ದೇರ್, ವೆದರ್ ಇಟ್ ಈಸ್ violative of that circular or not, that's all. 33 villages and 3 villages. Then if you give the date, we'll come to this one.
This tomorrow. Yes.
At request of the council for the appellant. This tomorrow. First to get.
Serial number 4. Subramanya Prasad. Serial number 4.
Respondent number 1. Respondents 2 to 5.
Is the position today? Is the school is being run from the same place?
No, they have shifted it long ago.
They have shifted.
They have shifted. That's what he has filed the affidavit.
This appeal.
In fact, in the affidavit filed in the writ appeal itself.
Where is that?
2911.
Where is that?
Even while the writ petition was pending, he had shifted it. That is, the court finds at page 127.
Even while the writ petition was pending.
That's right. Kindly turn to page 127 in the writ appeal papers. Page 127.
No, but that doesn't say so.
Paragraph 20.
No, but you see 21. Taking note of the respondent continues to run the dance.
No. Kindly, let's kind to page 127 in the writ appeal papers.
127.
There, paragraph 10.
Petition does not suffer any including conviction. No. This is This is neither here, neither there. Shifted steps including conducting classes from nearby temple premises, creating necessary infrastructure to the walls, windows and doors to see the sound dissipate.
Therefore, from the premises in question, they had shifted it to a temple then.
No.
Now kindly come to the affidavit in the writ appeal.
We want to know, why do they say creating necessary infrastructure to the walls, windows, doors to see that the sound dissipate? Further is in the process of obtaining expert opinion, window system will appear.
Now kindly come to paragraph 2 of the affidavit filed in the writ appeal.
Page.
Paragraph 2.
Para
2. The appellant has already started conducting classes.
Yes, pages.
That's the affidavit, the copy served to me bears the date 29/11/2019.
Page number.
Writ appeal.
Filed in the writ appeal.
Separate affidavit.
Separate affidavit in the writ appeal.
Page 149. And then the affidavit dated 17/7/19, huh?
The affidavit that is given to me bears the date 29/11/2019.
You appear for whom?
I appear for the writ petition.
Writ petitioner.
That's right.
Then you have now any grievance?
I have no grievance. It's his appeal.
No, appeal is you succeeded before the learner single judge.
That's right. I have succeeded before the single judge. And 2 counts. Number 1, the pollution board's report is there is noise pollution.
Pardon?
The second reason is it is in a residential zone. That is what the corporation contended. And they have taken steps to direct his evictions.
What does this affidavit say of 29/11?
The appellant has already started conducting classes in 2 separate premises, which are away from the locality and are located in commercial areas.
Now, have they started any other activity other than dance?
In the premises in question, nothing is going on.
Have they started any other activity other than dance?
We have no idea.
You have no idea. It's not troubling, they are
But
not
anyway,
troubling you.
anyway, they have said they have shifted the classes. They are
They say so.
already conducting the classes. Therefore, they are conducting the classes in an altogether different premises.
Paragraph 3
Of the affidavit.
of the same. Proposes to carry limited activity of the dance class in the subject premises, 1 class with maximum 2 students for preparation ahead of Avandatham.
But this is the affidavit that he filed. Then I contend who is there to ensure all this?
Conducting, see, you are the petitioner who
That's-
had come.
But he says, I will just teach only 2 students the dance class at a given time and all that. But can these things be ensured by the court? Are enforced by the court or ensured by the court?
Right, we are there to ensure it.
Let's see.
But we want to ask, it was at your behest you had come. Now, are you saying that there is no issue now?
Now, nothing is happening in the premises in question. They have shifted it altogether.
But they say so, two students.
They said so in 2019. But thereafter, absolutely nothing has happened.
Puja during festivals not involving any kind of dance. Conducting theory classes, prescribe mock test for students not involving any.
Whatever he says he will do, nothing is done so far. It's more than 5 years since his affidavit is filed.
Please come. They come and. From 26/5/23. Respond.
Just say this, there is no appearance for the appellant. Stop. Shall we pass over this? We'll just pass. Just pass over, let us see. If someone comes, fine.
Number 5, Mukkanappa.
I am for respondent number 2, my lord.
Yes, just give the file.
I appear for the respondent number 2, contractor. It's an award of the labor court which was challenged by the first respondent before this honorable court, and the writ petition was allowed when the award of the labor court granting relief of reinstatement and 50% back wages to the respondent at the first the first respondent before this honorable court is assailed here before my lords. Now my friend says, the workman, I am for the contractor. I have no role to play in effect. But whatever evidence had to be led to show that he is my workman, I complied with before the labor court, and also the learned single judge accepted my evidence. Now he says, I don't know. My friend says that there is a possibility of settlement between him and the first respondent principal employer.
Now the liability has been fastened on whom?
Nobody. As on today, the award of the labor court is set aside, and the relief earlier granted by the labor court has been set aside.
Labor court granted back wages.
50% back wages.
50% back wages reinstatement. So that has been set aside.
Please, madam.
Now what is his age?
He must be around, here in the writ appeal, it says 47. Now he must be 57. 2014 only, 47 antide. So 10 years now, it's about 57.
Why? Who has terminated him?
Nobody has terminated. That is the fact.
Then where is the question of reinstatement? There is no termination.
My lord, it so happened that I contended, I am the employer of the respondent. I said, I have not refused. You can come back to work.
So you said that?
Yes. In the very first initial stage,
He didn't come back.
he didn't come back on the ground. He claimed that he is a workman of the principal employer and not my employee.
So there was no claim against you. And against the principal employee, what is the finding of the labor court?
That the principal employer is the employer of this.
But that tests which have been laid down,
All those,
camouflage,
every document produced by me in my capacity as contractor was accepted by him, admitted by the appellant.
no, but that allegation would be against principal employee.
True, my
Sham
lord.
and camouflage.
Sham and camouflage was not the issue involved in the reference. It's application 10(4)(a).
That's the test.
No, but that was not the issue raised. That was not the allegation. No, no. The dispute raised by him was not on the count that I am only just an agent and the agreement is a camouflage or a sham.
Okay, let's ask Mr. Kumar. You tell us now, what is the foundation of your case? For seeking a permanent appointment against respondent number one.
May I interfere, my lord? The principal employer's factory is also now closed for over a year now.
Who, the one also?
One.
The principal
And my
employer?
services as a contractor also has come to an end. So,
Was it a brief period? How much?
no, it was for about, my lord, the award is of 2006.
Tell us, Mr. Kumar, what are you getting there? Yeah, argue it. He say respondent number one doesn't exist.
Factory is closed. He is also aware of it.
No, I think we will hear it. We will hear it. If you succeed, whatever it's worth, you will work it out. Yes, sir. Whatever it's worth. We'll come back after lunch. We'll hear you. No. We'll hear it. We have to do some work, Mr.
May I, my lord? Again, sorry for the interference. Some talks, more or less, for finalizing the amount seems to have been reached between the appellant and first respondent.
Tomorrow.
If that happens, I think that should be the end of
We'll
it.
try his life until tomorrow.
Please, oblige.
We know to.
Oblige.
Date ಕೊಟ್ರೆ list 2 ನಲ್ಲಿ ಯಾವತ್ತೂ ಡೇಟ್ ಇಲ್ಲ. ಅದೇ. ಅದಕ್ಕೆ ಸರ್ ಲಿಸ್ಟ್ ಮೊನ್ನೆ
Small submission. Serial number 6, madam. For the state of this.
Who? 6 ಅಲ್ಲಿ ಯಾರು?
The first respondent, or the first respondent in the writ appeal, my lord, he passed away. In fact, my lord, during the pendency of the writ petition itself, my lord, he's passed away. His wife was already on record. My lord.
One has been deleted.
Please, my lord, I already made a submission to that effect. My lord, I
You
remember.
are for R2.
R2.
No, R2 is also dead.
No, my lord, that information. What they are saying is they want to bring to the LRs of R1. One of the LR is already on record. My lord, there may be
children.
Other children also they want to. My lord, this is a case where, my lord, the matter attained finality before the Honorable Supreme Court also. They said it's a forest land, they issued notice, that was challenged before this Honorable Court, and my lord, that was quashed. State filed an appeal, writ appeal. That was also dismissed, holding that it's not a forest land. Then matter went up to Supreme Court by the Forest Department and the state. The SLP is also dismissed. My lord, I file a writ petition thereafter to give me permission to cut the trees. My lord, it was a collateral proceeding, not that issue. That issue was not involved. While again the matter came up for before this Honorable Court. This Honorable Court observed the issue regarding whether it's a forest land or not, my lord, already decided. So only direction requires to be issued is to cut and remove the trees. When again I approach the officer, he passes a detailed order and he says under Article 226, this Honorable Court could not have said so. My lord, that is why, my lord, the learned single judge has made an observation against the officer also. My lord, it attained finality in the 1980s. Again, in a collateral proceeding, they want to reopen the whole issue.
It's a matter of 19 again. If it has been already decided by the Supreme Court in that, what again, you have any?
But if they want, they have to acquire, my lord, pass a notification afresh, notifying those lands.
Acquisition is a
How?
different thing. You do whatever that is there. But now, where do you stand after the, huh? ಅದು ಆಯ್ತು ಬಿಡಿ ಏಜ್ ಯಾರ ಬರ್ಲಿ ಈಗ ನೀವ್ ಹೇಳ್ಬೇಕಲ್ಲ ಮೊದ್ಲು ವೆನ್ ಮ್ಯಾಟರ್ ಕಮ್ಸ್ ಯು ಶುಡ್ ಕಮ್ ಅಂಡ್ ಟೆಲ್ 2:30 ಪ್ಲೀಸ್ ಎರಡೂವರೆಗೆ ಬರಕ್ಕೆ
Call him, we'll be here.
ಶ್ರೀಮತಿ HR
Yes. Where is the award, copy of the award? He has attained the age of superannuation. When, which year? 2014? No. He expired also. He is retired. No? How would you answer this, man? It inured to his benefit. For 5 years, he continued. But tell us one thing, what prejudice has been caused for the delay? No prejudice to you. Prejudice to them. Delay is for not conducting an inquiry. Delay is not acting on an inquiry report. There is a difference. Why not 16 passengers? You have collected money and you don't issue tickets? What is the explanation? For 60, see, that can be a reason for not issuing a ticket for one person. I take the money. In the meantime, there is some fault in the light. I go and correct it. For not from 16 passengers collecting it and not issuing tickets. Why not back wages? What are the terminal benefits you are entitled to? Gratuity would otherwise be payable, no? Otherwise, it's payable. He is entitled to gratuity. See, gratuity under the payment. No, why not 2014? But in any case, he worked for till 14. That's That's right. Would he not get a benefit of these extra 4 years for gratuity? Oh, between 99 and 2010, there was a gap. He did not do. So he would now get the gratuity for that. That is something. Hmm. The delay has helped you. If you were, tell us one thing, if you were to be dismissed earlier, has helped you, they're not dismissing you, or they're dismissing you 99 help you. You continued for 5 years. We don't know, tell us one thing, we don't know what are the reasons why it was not acted upon. We don't know. There can be anything. See, for 16 passengers, how much he collected the amount? Pardon? In all? This is an incident of which year? What had not taken place? Oh, it was because of checking, he was caught. Similar charge, similar charge. Which paragraph? What was the charge here? There were two passing. How many passengers? Where is the past conduct? This statement is there, but without any switches. 25%. What he says is.
Back wages at 25%. What was that? That was of the first one, right?
See, this, there is no other ground of the, for the learner single judge, only one ground, the delay in acting on the report. That has not caused any prejudice to him, surely in the facts. But tell us one thing, as against 2 passengers, 16 passengers were not given. What is the intent?
Light was dim is applicable for receiving money also. Isn't it? Isn't it? That cannot be.
You're getting gratuity. Except that, period between 99 and 2010. But what about the 4 years? The additional.
That was not brought under. That
But
was
you don't
not
put
brought
it.
under.
You should have put it part of the charge. Right? You're not understanding. See, you would express yourself, look here. If the charges are proved, I will see your past conduct also in imposing penalty. Provided you put it to him. Where are those? Was it part of the charge sheet? That's right, you can say that. Let's see those 3 charges in your second show cause notice. See, here this award doesn't reflect so. Award doesn't reflect what you are arguing. Surely order of reflect, but it's not the order of dismissal. Is it the order of show cause? Does it reflect you intend to, you have put it to the workman that you intend to take his past conduct for determining the penalty? Where is that provision? Which page? Shows. Which provision you said? These are the regulations. Is it governed by an act? See, there is a sanctity given, there is a statutory provision to look at the past conduct. It's not 19 years, it's less than that. That's right. To 18, she says 18. So roughly around 18 years. Pick up 19 years of gratuity. With this. What other benefits he can get? What other benefits he got? Gratuity he got? Is it a pensionable? It's not a pensionable. Hmm. If the penalty is not dismissal, we will be entitled to pension. Dismissal for fees. What? Yes. 4 years gratuity. What she says is, if you count that period of 99 to 2010, it would be a huge liability on the corporation. Otherwise, she also trying to justify, given the nature of charge, he is not entitled to benefit. 4 years on the strength of an interim order, you continue, the gentleman continued. Possibly that's what we have put it to her. Once he has worked, would he be entitled to gratuity? Okay. She says possibly, yes, he may get it. What do you have to say? I don't know, but there are judgments now have come on this. There's also loss of confidence. Everything. No, you are reading this judgment, no? Which one? The Supreme Court judgment? Devendra Swamy. Yes, ma'am. How much have you quantified the back wages? Suppose he was to get, how much he would be paid? No, you're not getting. Let's assume we don't agree with you. This order stands. How much benefit would inure to him? Sir. Tell us one thing. Let's assume for a moment we write off that period, interregnum period, 99 to 2010. Then you will count the total period of service put in. Then whatever benefits that would accrue to him, you would pay. We don't know. When was he appointed? 85 till 99 is 14 years. So you have paid that 14 years. Then write off 99 to 2010. Then 10 to 14, he would be entitled. Then take this cumulative of this and treat the number of years of service put in and pay what are the benefits he would get it. Two things would happen. He is superannuated, he may get some benefit. According to you, the period of 2010 could not have been given the benefit thereof. You may be right. You're getting the point? That's what we want to say. Rather than this all consequential benefits, we will only, if you say we will only confine ourselves to the monetary benefit, 85, 99, 2010, 2014, all benefits, no continuity, no other benefits you would be entitled to. See, what we are foreseeing is this, that interpretation can include, you may seek other benefits also, like promotion. We don't know. Leave encashment. See, that's what we are on. See, it's a very serious charge, something like loss of confidence, thing like that. So to enure, if you have not got the benefit for this 14 years of service you have put in, 99 to 2014, any case you were out, 2010, you were out, you should not get the benefit. 2010, you came in on the strength of interim till 2014, you'll get the benefit. That's how I think possibly, but the benefit would be only to the extent of retirement dues. Nothing more than that. You don't know. Tell us one thing. Suppose you count this period and he gets leave encashment for X number of days, not the maximum. Suppose not 300, maybe 100 days. Why he should not get the benefit? We are excluding that period. Is only terminal benefits counting this period. Terminal benefits, according to her, includes leave encashment. So dismissal goes now. Dismissal has gone now. What is being done is only reinstatement. We are seeing reinstatement because of the fact that he can't now go back. That's the reason. Then what are the benefits? What are the benefits he would get? Tell us. Except that. I think better would be how much gratuity you got. I think they say they have given you gratuity, except the 4 years. Take 4 years of gratuity. I think let's put quietus. Tell us. You are right. That's in normal course. In a case of a dismissal, you forfeit everything. You can take now. The challenge in this petition. So that's what we return it to the order dated 28th September 2018, passed by the learned single judge in the petition number 7242 of 2015, whereby the learned single judge has allowed the petition filed by the respondent herein challenging the award dated 6/5/2014, passed by the Labour Court Mysuru in ID number 39 of 2000. Suffice to state that the petitioner was an employee of the respondent appellant corporation. He was working as a conductor, having been appointed on 21/10/1993. It is the case of the appellant.
Appointed somewhere back.
In 1985, say 1985. On 21/10/1993, it is the case of the appellant that while the petitioner was discharging his duties as a conductor, on 21/10/1993, in the bus bearing 7393 flying between Mysuru and Bacche Gaudana Halli, the same was intercepted by the checking squad at Kurhundi Road Cross. That is after 2 furlongs from Hulahalli, and issued a memo alleging that the respondent had failed to post the stage entries in respect of stage 8, that is Kurihundi, and failed to observe 4 passengers traveling without tickets in the driver's cabin from Hulahalli to Kurihindi. And that's 7 of rupees 2.25 paise. NIAC passengers were traveling from Hulahalli to Taraganahalli, and 9 of rupees 1.25 paise. NIAC passengers traveling from Hulahalli to Kurihindi. Thereafter, an article of charge has been issued to the respondent on 10/11/1993. The petitioner denied, the respondent denied the charges which have been framed against him. The inquiry proceedings were held by the inquiry officer who in his report dated 18/7/1994 has proved the charges which have been framed against the respondent. The inquiry report was served on the respondent, to which a reply was submitted by the respondent. It is a conceded case of the parties that the appellant that the inquiry report submitted dated 18/7/1994 was not acted upon till 1/12/1999, when a punishment of dismissal was passed against the respondent herein. The order of dismissal became a subject matter of an industrial dispute before the labor court in the being ID number 39 of 2000. By an order dated 6/5/2014, the labor court dismissed the reference against which the respondent filed a petition before this court. The said writ petition being what was the earlier writ petition number? 29. The said order became a subject matter of a writ petition before this court, being writ petition number
29301.
29301 of 2009. On 19/2/2010, an interim order was passed whereby the appellant corporation was directed to reinstate the respondent to service, subject to the result of the writ petition. On 24/2010, the respondent was reinstated in service, subject to the result of the writ petition. The aforesaid writ petition being 29301/2009 was allowed in part, whereby this court had remanded the matter back to the labor court for a fresh consideration, with the direction that the respondent to be continued in service till the disposal of the proceedings before the labor court. On 6/5/2014, the labor court held the charge as proved and upheld the order of dismissal passed against the respondent. Accordingly, on 21/5/2014, the respondent was relieved from service consequent of the award of the labor court. This award became the subject matter of a writ petition being 7242 of 2015, wherein the impugned order has been passed. We have heard the learned counsel for the appellant and also the respondent. It is stated by the learned counsel for the respondent that the respondent has attained the age of superannuation on 21/7/2018. On the other hand, learned counsel for the appellant would challenge the order of the learned single judge to say that the learned single judge could not have set aside the labor court award passed by the labor court. That too, when serious charges have been framed against the respondent. It is also her submission that even the past conduct of the respondent was such that the dismissal was the only penalty which could have been imposed on the respondent. She has relied upon certain judgments in her favor to contend that in similar circumstances, the Supreme Court has clearly held that the labor court having having held that the inquiry proceedings were proper, comma, it could not have interfered with the penalty imposed on the respondent. Full stop. It is her submission that in the present case, though the labor court has upheld the penalty, comma, the learned single judge has set aside the same, which is contrary to the spirit of the judgments laid down by the Supreme Court. Full stop. On the other hand, learned counsel for the respondent has relied upon a judgment of the coordinate bench of this court to contend that the delay that has occurred between the date when the inquiry report was submitted by the inquiry officer and the date when the dismissal order was passed, comma, the same has initiated the proceedings initiated against the respondent. Full stop. Related against the respondent. She also submits that the petitioner shall be contended with the terminal benefits. If the respondent shall be contended, if the terminal, she also submit that as the respondent has attained the age of superannuation, he would be contended if the terminal benefits are granted to him, counting the number of years of service put in by him. On this, the submission of learned counsel for the appellant is that concedingly between the year 1999 to 2010, when the proceedings were pending before the labor court, the respondent was not gainfully employed with the respondent, and hence the benefit of said period cannot be granted in favor of the respondent. Full stop. Full stop. She do concede to the fact that the 4 years of service put in by the respondent on the strength of the interim order passed by this court, the respondent may be entitled to the benefit of gratuity. She also submits that for the period of service put in by the respondent, the corporation has already paid the gratuity. Already paid the gratuity, that's right, ma'am? Has already paid the gratuity. Full stop. Noting the rival contentions made by the counsel for the parties in the facts of this case, when the inquiry has been upheld by the labor court and the labor court has also justified the penalty imposed against the respondent, which penalty has been set aside by the learned single judge. By stating in paragraph 9 as under, and also the fact that the respondent has retired, has attained the age of superannuation, keeping in view the spirit of the order, we are of the view that the respondent shall be entitled to the amount of gratuity for the total years of service put in by him, except for the period between 1999 to 2010. In other words, the petitioner, even if has been paid the gratuity for the period prior to 1999, he shall be entitled to gratuity for the period between 24/2010 to 21/5/2014. Respondent, now petition respondent. We will see that 21/5/2014. To that extent, the order of the learned single judge is modified. We make it clear that the petitioner shall not be entitled to reinstatement. Reinstatement in service with all consequential benefits, except to the extent what has been stated above. Okay. Dispose of.
Bill number 2. Secure housing.
Yes, this was the same. None for the appellant even on the second call. The even on the second call, the appeal is dismissed for dismissed in default and non-prosecution.
Serial number 3 adjourned, serial number 4, Subramanya Prasad. 4.
We just wanted to know, does any grievance arise? Grievance was his. The respondent number 1. What is the position today? No, you have shifted from the premises which is above the dance school or below the dance school. Oh, sorry, yes. Dance. So you have stopped that activity? Pursuant to this. What? Then we have to look into it. But tell us one thing, you see your counter affidavits you have filed. They will tell you, there is an affidavit filed on 29/11/2019. You see para 2 thereon. Has already started conducting 2 separate premises which are away from the locality and located in commercial area. However, requires the usage of the premises in question for certain activities till adequate soundproofing measure. Proposes to carry out limited activity of dance class in the subject premises based on 1 class, maximum 2 students for preparation of income. Conducting theory classes, mock tests for students involving dance, conducting puja. Tell us one thing then, how would you justify your actions? How would you justify it? Forget that, it's not relevant. Small or It's the sound which matters. Forget it. That's something external. You can't help it. Even he can't help it. But from in the scale of 10, from surely 10 to 8, you can reduce it. That's all. If you don't do the activity. That's what he's saying. Something 8 I have not in my hands. Something more between 8 and 10. I can do everything in my ability to mitigate the sound problem. Okay, no one is asking me. That's right. In the eventuality, you continue with the applicant. That's what he says. Continues to run the dance school in the interest of it would be appropriate to provide 1 month validity. Short arrangement to make alternative. One is stopping you to come back.
See, background noise levels was 41 and 60, 37 and 66. But with the dance classes going on, it was 73, page 24.
Get your instructions. Day after.
Then tomorrow. Okay.
Tomorrow. Get your instruction, discuss. What can you do? Who was the counsel who was appearing for the respondent number 1? Tomorrow. Re-notify.
Number 5, Jan 6, common docket.
Yes.
Next Monday.
You have to file that application. There are other in-laws also.
Hello?
Who appears for the respondent? 2, no? Are there any other LRs? But why they were not brought on record? Who said that they were an application? You only said no, you want to file an application.
Yes, my lord. I've given instructions to the forest officers to seek the details of the LRs of remaining LRs of the first respondent. If the respondent number 2 is giving the details of those, I will take necessary steps against them also, my lord.
Yes. Where is that Supreme Court order? Reserve forest.
It's not there in the Supreme Court order.
Finding that it's not a forest land and the revenue bank, you ask the liquidation first. There are you pay 120, there will be additional fees that will must be taxed and 150% additional from the land which has been entered to them in the forest land. If other container that is land to land to Goma land from develop, there is no material on record to show that they are not Goma land, but only forest land. In fact, land is very land order is there. The subject matter of land constitutes the part of the Goma land. It is therefore to make a only after the understood in the there is absolutely no material except assumption of the first respondent that the petitioners are computation to forest land. The records of the government on basis of which the land was made, the petitioners are sufficient to indicate that the lands are Goma land and not forest land. If the government petition was not sure that the lands were Goma land, not forest land, but did not think that it would have ventured to grant the lands to the petitioner. There appears to be some communication gap between the Revenue Department and the Forest Department to be responsible for the direct of the situation and not concerned with the question whether the first respondent. then whether the first respondent has the power to issue an order of eviction in respect of. But that's one of the notice was flashed and dishonorable court said they are Roman. But this was challenged in recently by the state government. Though one of the forest officer was a party, the rainforest officer and regional forest officer were party to the that was challenged in the state government of annexed E, state 131 recently. Because it is 050 of 1990. State 131.
So you continue to be in possession?
Yes. Annexed after the Supreme Court order. Under the Supreme Court order is that annexed. And it is, this is not.
When they want. Speak, madam. We notify Monday. Monday.
Number 7, appearing for the appellant in this case, my lord, prays for a 2 days accommodation, my lord. Argue senior, I have engaged the services of senior counsel, my lord, he is not in station, my lord. I have informed the other side.
Yes.
Prays for a 2 days accommodation, my lord.
All translated copies are there?
Yes, my lord, we have already filed, all the translations are there, synopsis also filed, madam. Only a 2 days accommodation, madam.
Do you want?
Friday.
Okay, we'll have it Thursday.
Please, ma'am. My lord, 27.
We'll notify first. Yes.
27-6. Serial number 8, KB Muralidhar. Serial number 8.
You appear for whom? Respondent college. Yes, now was she a party before the learned single judge? She was not a party. Okay, okay. You appear for the petitioner before the single judge. Did this appellant had also applied for the post? She applied? What happened? She was not selected. Pardon? But the appellant was not selected. Was she called for the selection process? How do we get that? Was she called for the selection process? Huh?
ಇವ್ರು ಹೇಳ್ಬೇಕು ತಗೊಂಡಿದ್ದೀವೋ ಇಲ್ವಾ ಅಂತ.
Certificate of job oriented course which is said to be equivalent to the 2 years pre-university course.
JOC is not equivalent to the second PUC, my lord. JOC is not equivalent to the equivalent. That is the issue involved in both the cases.
Equivalent to the pre-university.
Equal to 2 years pre-university course. This is correct. That's what.
JOC is not equivalent to the +2, my lord.
This was your case before the single judge? Was
No.
it your case before the learned single judge that these are not equivalent qualifications?
Just a minute.
Did you file any objections?
Yes, my lord. We have filed,
That shows that.
we have filed the objections.
On the basis of government advocate, the direction is issued by.
See, what the stand which he is taking would not help your case. He said they are not equivalent.
Yes, my lord.
You are not eligible.
Next year, my lord. Yeah.
See
So by
that.
the.
Where is your objection?
File objection.
Over respondent number 6.
Yes. Then 11/2021. There are 5 of the.
Where is your objection?
Just a second.
Objection file ಮಾಡಿದ್ರು.
ನೋಡ್ತಾ ಇದ್ದೀನಿ. Just a second. Objection is not filed, my lord. Mandela.
But then how are you saying they are not equivalent? Which is the annexure on which you are relying upon?
Yes, my lord. I will file my annexes.
Yes.
Sure.
Annexes. Oh, my lord.
Make sure.
Oh, at page 63 and 65.
Shall I make my?
See, there is a annexure Q. Holds that both
Shall I make my submission, madam?
they are equivalent. Narasimha Kapoor case is court formulated 2 points for consideration. UC and research examination are required admission which will be required for GOC. That is UC, diploma in vocation conducted with Karnataka State Council for Vocational Training and Directorate of Vocational Education equivalent to PUC conducted by the Department of University Education. Answering that, that's grievance is that you are. That's grievance is not your.
Did she apply for the post?
Appellant.
The appellant,
Yes, my lord.
she applied?
She applied for the post. She is the next to the sixth respondent. One thing, the respondent number 6 is relying upon the certificate issued by an officer.
Why didn't you make her a party? You declared her as a, as qualified? As- did you declare her as qualified for being appointed?
No, the college has to decide, my lord. President,
Did
the
they,
president.
did they declare her selected?
I have to look into that, my lord.
She would come.
Coaching the.
For the appellant, we notify. Yeah. Yeah. Come day after tomorrow, get your instructions.
Yes, my lord.
Serial number 9, Srihari.
Appearing to the appellant. The appellants in-laws are the respondents, private respondents in the writ petition filed by the respondent here in Millards.
In that writ petition, my lords, an order passed by the land tribunal, my lords, dated 13/10/1981, granting the occupancy rights in favor of the grandfather of the appellant herein, my lords, was challenged. And the learned single judge, my lords, has allowed the petition and remanded the matter back to the land tribunal, my lords, and the appellants are aggrieved, my lords. Lords, the case of the appellants herein is, my lords, that their grandfather, one Christine Castellino, was the tenant, my lords, under the landlord, one Mr. Bhujanga Rao. Lords, with respect to several properties, my lords, as on the appointed date, my lords, that is 1st March 1974, my lords, he was the tenant and Mr. Bhujanga Rao was the landlord. And my lords, after the advent of the Land Reforms Act, my lords, the grandfather of the appellants, my lords, Mr. Christine Castellino, has filed an application in form number 7, my lords, that is dated 4/12/1974, my lords. And later, my lords, during the pendency of the application, my lords, Christine Castellino died, and the appellant's mothers, my lords, and the uncle, my lords, who are the LRs of the original grantee, my lords, came on record. And subsequently, my lords, their application was allowed, my lords, by virtue of the order dated 13/10/1981. And subsequently, my lords, form number 10 was issued on 26/11/1986, my lords. And their names have been entered, my lords, in the RTC, and they have been in possession and enjoyment of the property, my lords. Now, the case of the respondent is that, my lords, he has purchased these two properties, my lords, that is 10/2P2 and 192/P2, my lords, measuring 30 cents and 2.84 acres respectively. He has purchased this property from the landlord, my lords, Mr. Bhujanga Rao, on 1/8/1974, my lords, which is subsequent to the appointed day under the Act, my lords. And his contention is that, my lords,
Please come to para 6, ma'am. Please read para 6 onwards.
Please, my lords.
Let's see the finding.
Please, my lords. May I read, my lords?
Yes.
On going through the material on record, it is clearly seen that the sale deed which is executed in favor of the petitioner's father, Victor Castellino, is subsequent to the appointed day, that is namely 1/3/1974. The RTCs, which are now produced at the time of arguments by the learned counsel for respondent number 3 and 4, would indicate that as on 1968-69 and thereafter, the name of petitioner's father is also shown in the column meant for cultivators, namely 12/2 of RTC. And as on the appointed day, he was also shown as one of the tenants. Admittedly, the said lands were under the ownership of one Bhujanga Rao, and the same was managed by one K. Padmanabha Rao as his power of attorney holder, and Bhujanga Rao has secured the said lands in a partition in his family. It is seen that the land bearing survey number 192 measures 5 acres 68 cents and 10/2 measures 1 acre 76 cents, and column number 9 as on the appointed day indicates the name of Bhujanga Rao as owner. However, when it comes to column number 12/2, there are several persons wherein different extents of lands are shown under their cultivation. But the said column is not clear about the extent of land held by each of the persons who is shown as cultivator. In fact, there is some confusion with reference to the extent of land which is under cultivation of each of the persons shown in column number 12/2 of the RTC. In any event, after the lands were purchased by the petitioner's father, it is seen that his name is entered in RTC as shown by the counsel for the petitioner. When that being the case, as and when the application was filed and the matter was taken up for consideration for issuance of occupancy certificate to the tenant in form number 7, nothing prevented the land tribunal in issuing notice to all the persons concerned to verify whether they have any say with reference to the claim of applicants seeking occupancy rights to a portion of land referred to in their application, which exercise is not done by the land tribunal, though the name of the petitioner's father, Victor Castellino, was shown in the revenue records, namely RTC and other documents as person owning certain extent of land, land title of which he has secured from the very same owner, K. Bhujangarao. Incidentally, this is not a case where sale by the original owner is in favor of a third party, but it is in favor of one of the tenants. However, there are other tenancy claims against the lands, and as stated earlier, petitioner's father himself was one of the tenants in respect of both the lands bearing survey number 10/2 as well as 192. Therefore, when applications were filed seeking occupancy right in respect of some portion of said lands, the tribunal ought to have exercised caution judiciously in trying to notify all those who are concerned in whose name RTC entries are standing, which is not done. One more defense which is raised while hearing this matter is that one of the lands which is considered for grant of occupancy right is survey number 192, which is said to be Punja land, as could be seen from the RTC, which is produced by both the petitioner as well as the respondent number 3 and 4. Admittedly, legal position on that is very clear that tenancy claim against Punja land cannot be considered. Therefore, even assuming that petitioner is a non-suitor, an error is committed by the land tribunal in considering the application seeking occupancy right in respect of Punja land, which ought not to have been considered by the tribunal. Therefore, to set right that mistake, the matter is required to be remanded.
Punja land was considered in favor of the respondent. Not have been considered in favor of the respondent.
That is the Millards, that is the finding. Millards, however, Millards, the RTCs of both the lands, Millards, produced before this honorable court do not show that they are Punja lands. They are Kushki and Bagait lands, and they are.
Kushki means in Dakshina Kannada.
And Millards, there are judgments, Millards.
Punja means non-cultivated.
Punja means non-cultivated, Millards, but Millards, it is also held by this honorable court, Millards, the division bench of this honorable court, that if the Punja lands are brought under cultivation, then it should be considered by the land tribunal while granting the occupancy rights, Millards, is the finding, Millards, of this honorable court.
Let's see para 9.
Please, Millards.
In doing so, this court is of the conservative opinion, impugn order is required to be interpreted only to the extent 2 items of land which are subject to the order of the impugn in 9 cents, which is the tribunal shall hold in the to them thereafter passing.
Millards, my submission, Millards, firstly, that the land was purchased, Millards, by the respondent after the appointed date, Millards, that is 1/3/1974. And Millards, the section 44 of the Land Reforms Act clearly states, Millards, that as on that date, all the tenanted lands are vested with the government, and all the encumbrances, Millards, are revoked, Millards. That is the clear, Millards, the statute has made it very clear. So the response.
How that will help you?
Millards, Millards, I am the tenant of the land, Millards. My grandfather has been cultivating the land, and admittedly, the land is tenanted land. It gets vested with the government, and I have sought for occupancy rights that has been granted.
Correct.
Please, Millards, that too way back in 1981, Millards, and the said order has been challenged by the respondent in the year 2012, Millards.
Correct. Now, after the remand, the tribunal has to consider who are the tenants as on 1/4/1974.
Please, 1/3/19.
1/3/1974.
Please, Millards.
Right.
Millards, he has purchased the land, Millards. He has been, Millards, it is a case where.
Purchase will not come in the way. As on 1/3/1974, the tribunal has to determine who are the tenants. If you are the tenant, then occupancy right has to be granted to you, depending on genuinity of your claim. But on 1374, the land vested with the
Statement.
state, provided it was under the cultivation of the tenant. Now, if the tribunal holds that it was not under the cultivation of the tenant, then that sale deed, etc., will come in play. Now you go there and show that you are the tenant, finished.
No, it is the case, my lords, wherein there are two tenants, my lords. My lords, the petitioner and the appellant and the respondent both belong to the same family. Lords, he has subsequently purchased the property from the owner, whereas my grandfather, my lords, has sought for occupancy rights with respect to very same land. My lords, your lordship may kindly see, my lords, the entire extent of this survey number 10/2 and 192/P2, my lords.
Yes, sir.
ಯಾರು? One tenant I purchased that land.
Did he purchase the land according to you?
My lords, he has stated that he has purchased the land on 1/8/1974.
After the cutoff?
After the,
The cutoff date will be, the effect thereof will be seen. See, on 1/3/74, the government is the owner, or vests with the government.
it vests with the government.
So it's only occupancy rights which you are seeking, and you may be seeking occupancy rights on the strength of, you being the tenant.
Please, my lord.
So that date would be relevant. And if your case is and his case is also 1/8/74, the consequence will flow. Whether it will flow in or not, that will be looked by the tribunal.
My lords, that being so, my lords, my one more submission is that, my lords, the order was passed in the year 1981, which is sought to be challenged, my lords, in the year 2012. My lords, I have placed all the documents to show that, my lords, that he had complete knowledge of the order passed by the land tribunal. My lords, the form number 10, Sagwali Chit.
Just 1 minute. Now, between that date 81, what is 81 impugning the proceedings of this? Where is 81 document? Is it on record?
Please.
13/10/1981.
Please, Annexure A, my lords.
Sure.
Annexure A, my lords, is the order passed by the land tribunal. It is at page number 30, my lords. And
Who are the appellants?
my lords, there, my lords, the original, the LRs of original grantee, my lords.
Who are the original?
Original grantee is one Christine Castellino.
Lucy Castellino, if you see page 30.
Please, Lucy Castellino, Emmy Castellino, Paulin Lena Castellino, and Steny
So you
Castellino.
are claiming your rights under them.
Please, my lords.
And you have been enjoying the tenancy right after this date? Till he
Please,
filed-
my lords, even today, my lords.
Till the impugned order was.
Please, my lords. And my lords,
And this order is of 81.
1981, my lords.
Did the respondent appeared in these proceedings? Before the.
No, tribunal not appeared. I have not
Yes.
appeared before the tribunal. I have, my very specific case is that I have no notice.
Who was in possession of the land?
I have been in possession of the land. They have tried to interfere. They brought the surveyor, in 2012, they interfered my possession. Then they claimed right. Immediately, based on the tribunal order, I came to know that they are claiming right. Therefore, immediately I approached this honorable court.
Lords, may I draw your
I have
lordship?
been in- My submission is that since I have been in possession, I requested the owner, that is the Bhujanga Rao, to transfer the right. I paid the money and I purchased the land in 1974.
But what is the effect after 1374?
If it, of course, my lord,
Whether you could have done
I
it.
can say, if it is the tenanted land, then it is with the government. The tribunal has to decide. Then they have not produced even single piece of document to show that they are tenants. Apart from that, they claim right in a small portion in a larger extent. They admitted the land in extent is more, then they have to give which portion. That is the ruling of this honorable court. They have to say which portion. If there is a larger extent, 5 acres of land, if he is claiming certain portion, then he has to state which is the boundaries he has to state. He can't say which is, without that, the tribunal has no jurisdiction, has to decide which portion.
We continue tomorrow.
Please.
Can I make a request? The next matter, serial number 10. Tomorrow and day after, I have some difficulty. Can I do it on Thursday, my lord? Let it be in the list, but I will do it on Thursday, my lord.
We'll continue in the list only.
It will be in the list, but I will,
Let someone be there from.
my
your-
colleague will be, Avar will be there, my lord. Grateful to your lordship.
List number 2 will continue.
I know, my lord, until disposed of. That's why I said let it be in the list, but
Do not vanish.
humble request
This
is,
status quo.
be very well. I understand.
Yes, sir. Thank you.